May it please your lordship.
Yes,
My lord, I would like to bring to your lordship's kind notice
yes.
a news item. My lord, this is regarding, there is a place called Jorabad where there is a tri-junction. Straight we go to Upper Assam, on the right we go towards Meghalaya. My lord, that place is inundated by flood every time there is a spell of rain. And for the last decades, this is happening. The authorities are absolutely silent. In my humble submission, my lord, this is a matter which is a.
Why can't you file a PIL?
But I have brought, but this newspaper report I have brought it. Based on that, also it can be done. My lord.
That's right, but it will be better if you put in more details. Newspaper reports, if it is very urgent, it is a regular feature. We could do it. But then if at all you're serious about it, why can't you file
Okay, I'll file it.
a?
I think that will be.
And then you take more inputs, more than what the newspaper gives.
Okay.
Otherwise, we can always take it up suo moto.
The idea is to, I mean, solve
That's
the
right.
problem.
That's right.
And not to fix responsible. Whatever happened.
That's right. So why we are initially reluctant to take it suo moto on newspaper report for the reason that this is not for the first time that it has happened. So you're aware of it.
Recurring.
Recurring. So therefore, I think the better option would be to have a
We'll do
petition.
that.
And you can base your petition on the newspaper report.
Yes.
Plus, you can make it even more comprehensive by adding few other information.
We'll do that.
Yes.
Deeply.
Adjournment request, if any, from item number 1 to 3.
Hello, in connection with the PIL item number 2, I am appearing for 4 respondent, my lord.
Yes.
12, 15, 35, 38. I was supposed to file the affidavit my lord, today, but my person could not come from Badalpur there. So I pray for little accommodation, my lord. To which time?
And have you informed the other side?
Uh,
Have you informed the advocates?
petitioner?
You must inform the petitioner, other respondents.
Yes,
Because there were
but
4 of you who were to file affidavit.
we had to file affidavit. There was order from you.
4 of the respondents, private operators,
Yes,
town
yes.
crushers.
Yes.
And you have to give an undertaking that you shall not do it and that you have not been doing it.
No, we are not
The
doing
Mr.
anything, my lord.
Advocate, Mr. Advocate General is appearing in the matter. He is coming. Yes, Mr. AG, he wants time in item number 2. Item number 2 may not be interest to you, but on the last occasion I had said that we will be taking your assistance.
Item number 2, PIL.
Okay, but in any case,
Cashing machine on the Badalpur.
it's with respect to limestone crushing
Uh.
and making of gravels.
Lordship,
You have no idea. No,
Yeah.
doesn't matter. He wants to take time. Therefore,
next day I'll appear, Lordship. No interest.
all right. That's great for by Mr.
S.C. Biswas.
Council for respond number
12, 15, 35, 38.
12, 15,
35, 38.
38. The matter is adjourned to give after 2 weeks.
Lord.
Inform the other side.
Sure, sure.
Yeah.
Now, Mr. AG will like your assistance in the matter.
In that case, Lordship, if in the registry may be directed to show a government advocate's name or my name, AG or some, then
GSM, it is written, but then nonetheless, GSM will be there.
Lord.
We are not asking the person concerned to go out of this case.
Lordship,
But if you're there, we'll be passing certain orders here.
Lord,
That way,
I'll be here, Lord.
some preliminary note
Lord,
I have dictated.
Lord. Deeply obliged.
19.9. Adjournment request from item number 4 to 13.
Fourth, sir. Adjournment request. Sir, adjournment request.
From item number 14 to 22, adjournment request.
My lord, in item 15, we have circulated a slip, man.
Item number, this is item number
15, man.
50.
15. Yes, as prayed for. Re-notify. 3 weeks.
October.
How late?
16 October.
May it please your lordship, I beg to mention item number 18.
You have circulated.
Yes, lordship.
A slip has been circulated seeking adjournment in the matter. As prayed for, re-notify 3 weeks.
14 October.
Much obliged.
Please, your lordships. Lordships, with the consent of the parties, I beg to mention item number 22, lordship.
Item number
22, lordship.
22, yes.
I'm seeking your accommodation for today, lordship.
You're for whom?
I'm for a petition appellant.
You're for the appellant.
Yes, Lordship.
All right.
Can it be on 15th of September, Lordship? As agreed to by all the parties.
15th is Monday, no?
Yes, Lordship.
Yes.
Deeply applied.
Let this matter at the request of the land counsel for the appellant. This matter on 15th. No, it has to go on a Thursday. On the next Thursday.
Next,
Lordship.
All right.
18. Any other request?
May I please, your lordship? This is an requesting for urgent listing of a matter. Connection with WBC number 3421 and the filing number is 1083625. Lordship, the urgency is that here my learned colleague, Mr. B.D. Daka is engaged in this case. And hence he is from 1 to 13, he is unavailable as he is going to England and the
I
matter is,
You
But-
want an urgent listing, but you're talking
Yes.
about some difficulty of an advocate.
yeah, no, lordship, it has to be, my humble request is to be listing for tomorrow.
Humble request for listing it tomorrow. What is the matter?
Matter is encroachment, illegal encroachment regarding the railways in Panikati division land encroachments.
But who are you? Is it a PIA?
Appeal.
Writ appeal?
Yeah, writ appeal, your lordship.
Okay. All right, tomorrow. Tomorrow.
Highly obliged, lordship.
But tomorrow, would it be possible for the registry to place it? Keep it on Monday.
Monday?
Monday, lordship, he's unavailable from 1 to 13. That is why I'm here to.
It's not
request
available from 1 to
1 to
13.
13, your lordship. That is tomorrow,
Yes, yes.
because matter is very.
Who is your
urgent.
senior?
Yeah, B.D. Daka. He's engaged in this case.
Tomorrow.
Highly
All right.
Already filed. Already filed.
already filed.
Daily list for orders, item 1.
Yeah.
I have prepared convenience compilation because documents are all over the place and this may be of some assistance to your lordships.
Yes, what are these?
Yeah, your
You
lordship,
tell us the updated report, whether the order has been complied with or not.
lordship, no.
Background history,
Your lordship, I will show you it has not been complied with. Not only has it not been complied with, no real attempt to comply with it has been made. In
Let us
fact, your
come- let
lordship,
us first
may
come-
I step back a little, your lordship, and introduce you to
all right.
what has
all right.
happened, because
But
that will give.
Before that, you kindly do what we ask you to.
Yeah, sure.
Because that will be easier for us to handle. You show us that part of the order where there is a direction.
Your lordship, there are two orders.
No, the order passed in PIL.
The order lost passed in
89
PIL is in
14.
on page 24 to 35 of the compilation.
Oh, Chai, you are referring from compilation, all right.
Your lordship, it may be easier for you. I will
What?
take you to the pleadings also, but only briefly.
Meetings would not be required in this
Yeah.
contempt petition.
I think so, your lordship. That is why I prepared the
That's it.
compilation, because we'll go
So
through
where is the order?
page 24 to 35, your lordship.
The relevant portion, direction?
Relevant portion is para 4, para 9, para 11 and para 10.
Can't be so many directions, no?
No, your lordship, they are relevant. Your lordship asked me relevant.
All right.
The direction is
Let
in
us see- let
para
us see
10
4 first.
and 11.
Let us see para 4.
Just a minute, your lordship. The para 4 basically, your lordship says, I read. The Arunachal Pradesh government has filed an affidavit admitting that the survey was conducted by the government to upgrade the BRO road from Sede Pakro segment to make it a 2-lane road and also to pass through the villages as stated by the petitioners.
It is also admitted that lands have been acquired pursuant to the said proposal and compensation has been assessed and deposited with the authorities for disbursement to landowners. However, it is stated that MoF did not find the proposal of the state a feasible one. Then your lordship, taking your lordship to para 10. And just before para 10, the last three lines of para 9, your lordship, para 10 is on page 33. Last three lines of para 9, your lordship.
Yes.
The government of Arunachal Pradesh found the plan more feasible. Your lordship, I emphasize more feasible.
You're reading at paragraph 50, at page 58.
I'm reading it. No, your lordship, that is internal page, page 33 on top.
33, that's right. So last three paragraphs before paragraph 10.
Last three lines before paragraph 10, last three lines of paragraph 9. Lordship. Government of Arunachal Pradesh found the plan more feasible. This is the alternative alignment plan. Therefore, on scientific considerations, the project suggested above have been approved. Since there is no merit in the PL seeking setting aside the approved plan. Further, your lordship, in para 10, in view of the above said reasons, we find that PIL lacks merit granting relief of setting aside the approved plan. However, we notice that there appears to be.
I know, I can understand where are you leading to. Please read para 9 in
Right,
its
your lordship.
entirety. Then we know what was the prayer and what was the
Yeah.
directions of the court.
Yeah.
This is
Lordship,
only, this is
I,
only with respect to our assessment whether
Yeah.
the order has been complied with or not. Read para
just to
9.
make it easier, lordship, I have got a clear map which is not clear in.
Read para 9.
Okay. Upon hearing the petitioners and respondents, it emerges from the fact that the material there appears to be no mala fide or ulterior motive on part of Morth in accepting the proposed plan to build a highway between Sede and Pakro as per the design given by respondent 8. Lordship, that is the contractor. The government of Arunachal Pradesh also does not attribute any motive for the proposed plan for executing the construction of a highway between Sede and Pakro as per the plan of the 8th respondent. In the affidavit of 8th, it is stated that the villages so and so have connected with BRO road and the highway to be built as per proposal sent by state to cover the villages as stated by the petitioners is not feasible because it is steep terrain and the speed vehicles despite building a highway would not be 25 km/h, etc. 315 serpentine curves and the inclines and declines of the highway would be around 1090 meters.
That's right.
Now, your lordship, I humbly would like to submit here that respondent, their 8, that is the contracted, while in his affidavit laid out this better alignment, in its affidavit, it also included a alignment as per the old alignment, which it submitted as being fit. Now, this is a very important point.
That's right. Let's see the directions first.
So now the directions, your lordship, are, however, I'm coming back to para 10, your lordship.
Yes.
However, we notice that there appears to be a dire need for improving the BRO need existing in the named villages in order to have better connectivity with the townships and as well as to approved highway between Sede and Pakro. The Arunachal Pradesh government did feel the necessity of improving and upbringing the BRO road as a national highway and sent the needed proposal to Morth. The lordship, as far back as 2008, the proposal was sent of 2 alignments, the new one as well as the old one.
That's right, Mr. If we complete the
Okay.
order part, then perhaps you'll argue.
Okay,
in a
okay.
better way.
Lordship. The state has also acquired lands for widening the broad road, BRO road, and compensation has been assessed and deposited with the authorities for disbursement to landowners. Therefore, it is directed that the Arunachal Pradesh government shall widen the BRO road as per its proposal sent to the MoP to make it more convenient and to provide better connectivity to townships. Lordship, further in para 11, 5th line from the, in this regard, it is directed. Lordship, para 11,
Yes.
last 6 lines. In this regard,
Yes.
it is directed that the government of Arunachal Pradesh to take up the project and construct the road as per its proposal sent to MoP within a period of 2 years. The state of Arunachal shall complete the said road simultaneously with the Sede to Pakru approved road, which is the new alignment. which is required to be completed by 8 correspondents. Accordingly, the interim stay granted stands resolved.
Where is the direction to the Morth to accept it?
North and,
Where is the direction to, I mean, you understand what the court is talking.
yes, your lordship.
Now, this
The-
direction means nothing. It does not have the necessary claw. It doesn't have the necessary sting. It says the government of Arunachal Pradesh, and the court was made known that Arunachal Pradesh, feeling the necessity of improving the connectivity to villages by widening that BRO and connecting it with the main road, the alignment suggested by the contractor is better, but then the proposal was sent, Morth did not accept it. Where is the direction?
No,
of
no,
the
your,
Morth to
your
accept it?
lordship, humbly, may I try to aid the honorable court? Your lordship, this order clearly was understood both by the petitioners and the state to mean that, no, and I'll show you how the state understood that.
So you're asking us to read something sub silentio.
No, your lordship, if a simplicity reading,
Let's see.
a simplicity reading of this, it clearly says in this regard, it is directed very clearly. It is directed that the government of Arunachal to take up the project.
The government of Arunachal Pradesh was itself desirous of getting it done.
That
But
is mentioned,
The
yes.
difficulty was that Morth was not accepting it.
That
And
is
there is
why.
a statutory requirement that unless it is approved by Morth, the alignment cannot, I mean, we don't know what the estate
Your
is.
lordship, this is where I may like to assist your
Right,
lordship a
so
little.
let's first have the facts clear. and
Yeah,
then we'll
your
enter
lordship,
into it
if you
in
allow
fact.
me, I'll make the facts clear with the aid of a map, which will help in understanding what's going on.
Can I have name,
Abhay Kashyap,
Mr. Kashyap?
that's right.
That's a difficult proposition that you're suggesting to us. See,
Lordship, it's part of
map
the,
is not to our understanding.
lordship,
Map,
it's
you
part
can
of the
make us-
pleadings. It's part of the pleadings.
We are not disputing it. We are not asking you to not to produce the map for any want of such statement in the pleadings. No. We first want to ascertain ourselves what was the direction, what is the response of the state, and then we shall pass orders accordingly.
Right,
No.
right, your lordship. Lordship.
So therefore,
as-
don't get disheartened by initial
No, your
observations.
lordship, I am here to assist the court, your
That's right.
lordship.
So
In a contempt matter, my role is very limited, just to
That's right.
assist the court.
So therefore, we can't review the order.
I'm not
can't-
asking your lordship to review the order.
Mr.
Yeah.
You need not respond to everything that
Okay.
the court says.
Yeah.
We are only making you understand in what contours would I be deciding it? Would
Okay.
we be deciding it? So now look at this. Now, there is a direction to Arunachal Pradesh government to complete the said road project. Therefore, what you're suggesting to us is that this direction is with respect to the project, the alignment or the proposal which was made by the contractor. Correct?
Mhm.
Correct?
There are two elements, your lordship. One is what your lordship is just saying, but para 11 doesn't concern that. Right?
Yes.
Lordship, para 9 is exactly what your lordship have just said. But para 11 is about the old alignment which is being left out by the contractor, and Morth is supporting the contractor in the court, and based on scientific basis and finding it a better alignment for the purpose of the contract, that alignment is allowed by the honorable court instead of the old alignment of 31 kilometers. But then the court also notes, your lordship, the important thing here, when you allow me, I'll be able to demonstrate, is that in PIL 101, the stand taken by the state, Morth, and the contractor, R8, was that this new alignment is better and the old alignment is impossible. And in fact, they went to the extent of even saying that the money has been computed and calculated on the new alignment, the
That's right.
disbursement.
Great. So thereafter,
Now,
what
now,
happened?
your lordship, what happened? I was also party to this 101. So what happened is, when arguments happened, it was demonstrated that while
Mr. Kashyap, I will not be able to concentrate. I'm so sorry. Unless I am made to see the order and the response, and then only you can argue.
your lordship, this order,
You have to speed up a bit. I'm so
Okay,
sorry.
your lordship,
I'm not cutting you short. We will hear you as long as you want us to hear.
no, your lordship, I normally don't take too
Let's
much time.
just see. Now, this was the order. Then what happened? What is the what is
Your
the
lordship,
present affidavit of the state?
what happened after this? To appreciate that fully, your lordships may find it useful for me to assist you in why this happened. You see, we come in a PIL, do not change the alignment. The court says, no, I am allowing the different alignment. The matter should have ended there. But because of
Not
the,
necessarily, but.
no, I'm taking, I agree.
Comment. Yes, therefore, we are asking you, let us see, you are not here in any vested interest. We understand that. You represent those villages which would be left out if the old alignment is tried. If the old
That's
alignment
done, old is done, old is not done, your lordship, new one is done.
new one is done.
Yes.
Then what is the problem?
New alignment is not my problem, your lordship. We are on the old alignment.
You wanted old alignment.
We want the old alignment.
Where is the direction?
Your lordship, para 11, as well as para 10, are talking about old alignment only. Your lordship, this is why I'm trying to explain. Sede to Pakro, the original BRO road was of 30 kilometers. A segment was found as a new alignment, which is 15 kilometers.
Let us see their response first.
Yes, chalo.
What have they said? Have you brought it here in the compilation volume?
In your, you mean
The response of the Arunachal Pradesh government
you mean in the 101?
No, here.
here.
Here, your lordship, the response
In
of,
contempt matter.
Compliance.
in the contempt matter, yes, your lordship.
You have brought it in the compilation or?
No,
Look
it's
at the
not
record.
in the compilation because it's very
That's on
short.
the record.
It's very short and I can take you to that. It's R2 and R1's response. And also, your lordship,
This is the affidavit filed on behalf of respondent number 2.
Yes, by Secretary
Lordship.
PWD, my lord. On 27/3/25, where we have enclosed the compliance report and the certificate.
27.3. 27.3, yes. We have it before us. Page 217.
yes, your lordship. Lordship, this humble request, if your lordship were also to see the second order of this honorable court,
Just give us a minute.
your lordship, this is an affidavit given regarding in response to the order.
Yes, to check the
I don't think. Yes, now tell us. Now we have
Lordship.
understood.
Lordship. Lordship, this document is the additional affidavit which has been submitted by R2 regarding completion of the road. Based on an order in an IA filed in PIL 101 in, I think, September or around that time of 2024. And that IA requested for additional time. He also mentioned what they are doing, etc. And in that order, in that IA, an order was passed, which is on page 234 of the
So
said.
let's you dispute this statement made in the affidavit.
Pardon your lordship?
How do you dispute this statement made in the affidavit that it has
Completed.
completed?
Your lordship, I am going to show you that they have not even stated it is completed. The situation is that bad. The 15 kilometer which they have completed, first of all, your lordship, a road is a road is a road. Is not equal to the rows by any other name will also be a rows. Your lordship, a road is specifications, length, breadth, weight carrying capacity, etc., etc. They have first of all gone in for a PMG SPI road of 3.5 meter width. Excuse me. Lordship, the problem lies in the factual matrix itself. If you would kindly allow me to introduce the factual matrix, I may be able to assist better. Lordship, there was an existing road.
We require your assistance in a different way. Now, we can
Lordship,
complete
please-
it by this. If you go back to the prayer made in the PIL, what was allowed, what was not allowed, you tell us that this road, the NHD so and so did, this project is complete, fit for entry of operation.
That is, I am not concerned with that.
You are not disputing it.
Neither
So
disputing
therefore-
nor am I concerned with it.
So therefore, you need to say that the direction was this, that has been abandoned and a separate road has been made. That has been left unattended. If you say so on affidavit, we'll ask.
No, your lordship, your lordship, I am not being able to perhaps assist you as I should. Lordship, first, let's take the situation in 2013 or 2014 when the order came. When the order came in 2014, there were two roads.
So you have to tell me in black and white.
Lordship, I'm trying, if kindly give me some patient hearing, I will be able to hopefully meet your requirement. Lordship, there were 2 points between which there was an existing road. A new road was sanctioned and it has been made. That is part of the contract. I have nothing to do with it. Okay. The old road was called BRO road alignment of 31 kilometers. That was class 5 road as per affidavits and filed in PIL 101 as well as in IA 875. Classification 5 means it is a 4.9 meter road. This is the factual situation. My clients have measured it to be 4.5 meters, as with passage of time, it is broken the sides, the shoulders.
Look at this, Mr. Kashyap. Now we are asking you to file a 5 pages affidavit denying that the directions have not been, directions of the court is not fulfilled. So
Okay.
you tell us that the construction, the affidavit in paragraph 6 talks about a different road with which the PIL is not concerned. You want a different road to be
Lordship,
constructed.
I'll do that, but give me 5 minutes indulgence, your lordship. Just 5 minutes.
It would be an exercise in futility, Mr. Kashyap. We are-
Okay, your lordship.
You're absolutely full you're absolutely full of your case. There is no difficulty. We appreciate that. We appreciate that. But you know, the facts are spilling here and there. You do one thing.
That is the problem in this case. Your lordship, you have hit the nail on the head. That's actually a problem.
Now you make a 5 pages note. If you make a compilation which would be as thick as your petition or perhaps the volume.
Lordship, मैंने एक written submission बनाया. I have made a written submission.
Let's see.
That might fulfill your.
My inference, with so much of inferential logic, we don't punish the other side for contempt, no?
Lordship, it is a strategy followed by states to inundate with facts.
This is what I said. Old alignment report only said that that was the new alignment was never rejected. That prayer was rejected. The whole alignment they have not made it. And even if they have made it, it's less than 21. That's what he says. Not very-
1 kilometer and it is less than, not 4.9 meter, it is 3 point, something. 3 point.
Yes, who represents Arunachal Pradesh government?
No, I'm preparing for the contempt that they have included in this contempt petition.
All the contenders.
Yeah.
Right. His argument is very simple, though he makes it look like a very big problem, but that's not the issue. The PIL was filed seeking a direction of the court to abandon the new alignment and stick with the old alignment. Right. The PIL was rejected. There was no malifies, nothing of the kind.
Yes,
PIL was rejected.
my lord.
But in passant, a comment was made, a direction was issued that because the government of Arunachal Pradesh deems it expedient and has also taken land by acquisition, by process of acquisition,
My lord.
and the landowners have been paid, why not do that? From Sedo Pakro, from which place? From
Secretary to Pakra, Lord. You are correct.
Sede to Pakro. So that would cover some of the villages from where these writ petitioners belong. So that, with respect to that, they say that you have modified the plan, just a minute, the new alignment has been completed.
Mhm.
With respect to the old alignment, which was only widening of the BRO road for adding to its connectivity. So that he says that you midway, you issued tender under the Pradhan Mantri Rozgar Yojana number 2.
right.
So you have to dispute this.
My lord.
Otherwise also that, have you connected Sedo to Pakro?
Sadi to Patro is connected, man.
Forget about new alignment. Under
Sadi
the
to
old
Patro is
alignment, but the
connected.
villages
It's
have to be
connected.
covered.
1% of road, my lord, that is from the, my lord, there is a map in my affidavit.
Forget about map, make a statement.
My lord, 1% of the road was abandoned. For the simple reason is that the people staying there very sparsely populated, my lord. They have come down to near the highway, madam, which in the meantime has been constructed, the Trans-Arunachal Pradesh Highway. So in view of that, that particular portion is abandoned. The other bypass section has been constructed and completed, my lord, by virtue of the direction issued by this honorable court.
So
An extension of
in
time,
connection with the old alignment of widening of the BRO road,
my lord.
have you done that? Where is that statement?
My-
Where is
my-
the-
my lord,
we
my-
close the petition now. Where is that statement?
My lord, but your lordship, will kindly come to para 6 once, my lord, of the direction of the order.
Para 6 of the order.
Yes. But this is in respect of the affidavit filed then, man, and which was quoted by this court in its orders. Para 6, man, if your lordship has found it, the internal paging is 54, man.
Hmm.
The moth has
Hmm.
filed,
Yes, we have got it.
has filed an objection statement to rebut the contention of the petition in para 8, 11, and 17 of which the following amendments are made. 8. That with regard to the statement made in paragraph 7 of the PIL, the answering deponent states that the villages mentioned by the petitioners like Chamtia village, Gumtang village, Rasi village, Devagala village, Tangri village, etc., Hot village, and Dwala village are not in the existing BRO road, which is misleading to this honorable court. Hence, the passing of above villages does not arise. Bypassing of above villages does not arise. However, the other 3 villages, that is Sadi and Pizirang, is already connected, and Palin village is connected by adjoining road, which is liable to be dismissed with cost. Further, the final matter is after thorough survey done by the concessionaire, the contractor. Respondent number 8 with design consultant to the Transis Consulting Private Limited, and after comprehensive meetings with the state PWD concessionaire and site engineers. Hence, the same is not within the purview of the PIL. It is pertinent to mention herein that the existing geometry in the BRO road is very substandard with zigzag and hairpin bend curves without any horizontal or vertical geometry. In this section of the existing alignment, there are 315 numbers of horizontal curves at an average of 10 curves per kilometer and an average degree of curvature is 1338 degree per kilometer. These values show that the geometry of the existing road is very substandard, where it is impossible to develop, construct two-laning highway as per standard and specifications prescribed by the Planning Commission of India. Therefore, the geometrical improvement through realignment is prepared in conformity with the standards and specifications, thereby reducing the curves in order to maintain nominal speed of vehicle. The answering deponent craves leave of this honorable court to furnish the copies of improved alignment designed by so-and-so, so-and-so. That with regard to the statement made in paragraph 10 of the PIL, the answering deponent denied that the survey was initiated in the year 2008 by them and proposed to bypass the villages mentioned by the petition. The petitioners are in grave misconception with the tender process and work execution of normal NIT and the DFFOT. The instant project, that is DBFOT, that is to say design, build, finance, operate and transfer, which is based on so-and-so, so-and-so, so-and-so by the concessionaire and 80% by the MOT. So financing 80% by the MOT and operate and maintenance within bracket 17 years and transfer, whereas in normal NIT by CPWD, survey, drawing and design, they brought in the distinction between the present contract and the normal and CPWD. As such, in the instant case, which is based on DBFOT, the tender was floated by giving notification dated 18/10/2010 and after scrutiny of the same, the concessionaire and respondent 8 was awarded the work by concessionaire agreement dated so-and-so with a condition to hold survey and to design the same in conformity with the specifications and standards prescribed in the National Highway Manual of the year 2007.
Now, to straighten the facts, in the old alignment from Cedar to Pakro, you say that you tried to make that road in pursuance of the order of the court,
Yes,
but
sir.
because of the many hairpin bends.
And the standards set by the Planning Commission or the department, madam, more.
Rest of the
It was-
9 kilometers you have done out of that.
Yes, ma'am.
Out of 31 kilometers, 9 kilometers you have done.
Yes, ma'am.
The rest is impossible.
Lordship,
My lord, my lord, it's
Mr.
also not,
Mr.
my lord.
Lordship, this is a gross misstatement, your
I'm
lordship.
good, sir.
See, if the order was confusing, you should have come for a clarification.
Exactly.
Not
My
confused.
lord,
You should have come for a
Lordship,
clarification. We
Lord-
can't clarify it.
my lord, I fully agree, my lord. When we filed the application, my lord, at a later stage for seeking extension of time to complete the road, then also we made this submission, my lord. That was a grave mistake done on the part of the state, my lord. That is agreed, my lord. But there was no laches or negligence. All along we are, my lord, taking up this matter with the MOT because they are the ultimate, my lord, authority who has to give us sanction and everything, my lord. And we also produced, my lord, these bunch of correspondences made, my lord, before this court, while this court had passed the earlier order of extension, my lord.
Make a specific statement in your affidavit, file a 2 pages affidavit,
My lord.
that the new alignment which was possible has been constructed, it has been commissioned, everything has been paid also.
My lord.
The old alignment with which regarding which there was a direction in the PIL, that was attempted. You could complete 9 kilometers, but rest of the kilometers could not be completed because of the
This technical
difficulties with geometry. Geometrics. And say that, we will say whatever we have to say.
My lord.
Lordship, I may be also allowed to file an
Naturally, so
affidavit.
let him file an affidavit to that.
I'll also file another affidavit, your lordship.
Take note.
And one humble submission, just to point out. The statements which have just been made are false, your lordship. I'm sorry to say they are not even inaccurate. And I'll tell you why.
Then let it come on record and let you reply.
I will do that, my lord.
But in order to shorten it for our next hearing, we must state something, we must dictate something in our order, otherwise it shall remain as. Take note. A PIL petition was filed in 2013 seeking a direction from this court to the respondents not to abandon the final map of two-lane national highway from Nechipu to Hoj on the Sede Pakro segment, which earlier had been approved by the Ministry of Road Transport and Highways, bracket MOT, Government of India, and a further direction to the respondents to build the two-lane national highway in the same segment, that is Sede Pakro segment, as per the existing BRO road. There were other prayers also in the writ petition. After going through the pleadings and hearing the parties, the bench found that the PIL lacked merit in seeking the abandoning of new design with new alignment. However, while disposing of the writ petition, it was observed that there appeared to be a dire necessity of improving the BRO road existing in the villages pointed out by the writ petitioner. In order to have better connectivity with the townships, as well as to the approved highway between Sede and Pakro. Considering the fact that the Arunachal Pradesh government had considered the necessity of improving and upbringing the BRO road as a national highway, and had also sent proposals to the MORTH, which was never accepted by the MORTH, the court directed the Arunachal Pradesh government to widen the BRO road as per the proposal sent to the MORTH to make it more convenient and to provide better connectivity with the townships. While saying so, the court had taken note of the fact that for the aforesaid purpose, the state had acquired lands for widening the BRO road, and compensation also had been paid to the landowners. The contention of the petitioners in this contempt jurisdiction is that the new alignment only was followed, and which project has been completed, with which the petitioners have no quarrel. Mr. Kashyap, learned advocate for the petitioner, submits that there is no clear statement in the affidavit filed by the proposed contemners whether the direction issued by the bench for completing the project according to the old alignment, for which necessary acquisition of land was made between Sede and Pakro, involving around 31 kilometers, has been completed or not. With great efforts, we could find from the affidavit filed on behalf of the respondents that some part of the old alignment was attempted to be, the widening of the BRO road in the old alignment was attempted to be completed, but because of difficult terrain, geometrics, many hairpin bends in the entire length of such road, it was not possible to complete that aspect. to complete that part of the role. Mr. Kashyap, learned advocate for the petitioner, however, submits that such statement is factually incorrect. The learned counsel for the respondent shall file a 5 pages affidavit, a short affidavit, indicating as to which project has been completed and whether the directions of the bench in the PIL has been complied with. The learned counsel for the petitioner shall also have the liberty to put in facts in opposition to what has been stated by the respondents. Let the affidavits referred to above be filed within a period of 3 weeks after exchanging the copies of the affidavits with the learned counsel for the parties. List this matter for further consideration on. This could have been completed just
Lordship
now.
may give a fixed date, your lordship. The lordship may give a fixed date.
Date, there's no cases left undated.
No,
We'll
lord-
review them. After
Another,
3
another observation, your lordship, just to help the honorable judges. Your lordship, the factual, you have noted, North had never accepted that, may not factually be correct.
No, that's what the statement says in the order.
Yeah, but your lordship, factual is, the tender was
We
issued
have
as.
filed the affidavit, we have read that order. That's his statement.
Oh, you have to deny them.
We have said this, we have not said this from our knowledge, we have said this from the judgment. All right. You are a practitioner of this court or you come from outside?
I come from Delhi, your lordship.
Ah, you come from there. All right.
22nd September. October.
Much obliged.
15 October.
15th of October.
October is also.
Item number 3.
Item number 3, Lordship. On the last occasion, the other side said that they will file an objection to the delay condemnation petition, which they have filed. So there was a delay of 142 days.
No steps have been taken by you with respect to service of notice on some of the respondents.
In the other 4 cases, Lordship was pleased to already condone the delay. Other 4 cases, only 1 cases, they appeared and they said that we'll file the objection which they have filed.
But what is the purpose? We don't understand. I think you must be aware of the Supreme Court dismissal of the SLP.
That SLP has been filed by some other persons who were not party to the cases.
That's right, but giving no liberty, I mean, that judgment was under challenge, no? Just have a look at it.
I have not yet, because how can they?
The numbers of the writ petitions underlined are the ones who are there, who are the parties here.
Yes, Lordship.
Lordship, I am told that the persons who approached the Honorable Supreme Court,
Now, I was only looking at any, escape route. Whether you have been given the liberty to approach the High Court in division, in appeal, or anything, or review. Nothing of the kind. They
Lordship,
didn't find merit.
let the delay be condoned, Lordship, and on the next date, Lordship, I'll make my submission. I'll verify also, because my instruction is not.
That also appears to be difficult for the reason, Mr. Saikia,
Lord.
there are many respondents who are not here. Notices have not been served. You have to take steps for service of notice on response number 11 to 14, 16, 17, 19, 20, 24, 26 to 31, 33, and 34. You have not filed requisites.
No,
That's the report of my
the
office.
report, yes, Lordship, maybe.
So therefore, we grant further 3 weeks time to you.
Lordship.
But you,
That will be sufficient, Lordship. But on the other hand, they have already appeared.
Who have appeared? All respondents have appeared.
Lordship, please, my lordship.
Yes.
The respondents who wants, we are appearing for 8 respondents.
Okay, then Lordship will take, there was some confusion. So I'll clarify, and if required, if 3 weeks time is given, we'll take steps to those leftover respondents.
There's an application seeking condonation or delay of 142 days in preferring the appeal. The office has reported that some of the respondents have been served, whereas many have not been served, which would include respondents number 11 to 14, 16, 17, 19, 20, 21, 24, 26 to 31, 33, and 34. The office has also reported that no requisites have been filed for issuance of notice to the aforementioned respondents. On the asking of the Mr. Cycle and senior advocate appearing for the appellants, 3 weeks further time is granted to file requisites for issuance of notice to the aforementioned respondents. Notice by both modes, returnable, sometimes returnable.
Lordship,
I'm appearing in item number 6.
Yes, somebody is appearing online, yes.
yes, Lordship. I pray that Lordship, basing upon the respondent, 8 respondent has already filed,
Affidavit.
yes, their Vakalatnama. My lord will kindly mention that this is the second time it has come up. We have already filed our Vakalatnama from the first instance, but our names are not reflected. So that also may be noted.
So,
I'm from Kohima, Lordship.
that's right, you're MS Jimomi.
Jimomi, Lordship.
I remember your face because
Lordship recent.
next time only. MS Jimomi appearing virtually from Kohima submitted that she has received notice on behalf of 8 of the respondents.
Lordship, what if it becomes only the 8 respondents, Lordship? If that be the case, the case may not be delayed longer, Lordship. Because on the part of the respondents,
Whereas Jimomi, try and understand one thing, the judgment is in your favor.
of course, Lordship, of course.
It's only a matter of condonation of delay. Unless we condone the delay, we will not be able to finally decide the appeal. As it is, of ourselves, we made it known to the counsel for the petitioner that the SLP against the impugned judgment has been dismissed. So therefore, there is no escape route for Mr. Saikia. But then you should not raise this objection. Let this be done. Sometimes later, date would be fixed. They would be troubling themselves because there is a direction to complete the process within a particular time. That time was extended. So even within that time, we'll be first asking them, I mean, if it is
The government, Lordship.
we'll be asking the government what steps have been taken, at what stage is the process of selection. All this, they will be required, otherwise they'll be in contempt. Right? So therefore, don't worry about it. It is their interest that they would like to have it decided fast.
Lordship, here the problem is not even this go.
Just a minute. The interest of the respondents would be better served with the delay in admission of the appeal. See, nothing can be done once the Supreme Court has rejected it on merits.
Of course, Lordship.
We understand that. So let it be done. Let both sides be happy. There are persons who are aggrieved. They were appointed. They are still continuing, but they can't continue forever.
Yes, Lordship. Yes.
We understand that. So therefore, we have given 3 weeks time. Let them complete. On next day, we will decide, and we will put a final, a decent quietus to the entire proceeding in whichever way. All right. After Supreme Court has decided it, do we have the option of deciding any differently, and why?
Exactly, Lordship.
That's right.
Lordship, I'm appearing item number 6 for 8 of the private respondents. Item number 6.
Message before. There is no case method.
Similar.
No, it's a fresh matter, no?
Oh, no,
You seem to be in great hurry.
Lordship.
Deeply observed.
Let all these matters be listed
22nd
on return of the rule on
22nd October. 22nd October.
Lordship.
Mr. Saikia, after the documents that we have given to you,
Lordship.
Would you like to pursue it? Or unnecessarily?
My clients and my colleagues wants to pursue.
Can we do it? So let us see, we will cut down the delay just now, just
No,
say, and then.
Let it be after on 22nd of August.
But you'll be under great trouble, no?
The
You're
only
very-
thing is that they have bypassed this
Just,
forum.
that's all right. You are
At least if
you're
a dismissal,
appearing for the appointees. Who
Yes, Lord.
services have been done away with.
yes, Lordship.
Now, the state of Nagaland will be required to explain on the next day, what have they done for completing the fresh process?
Exactly, Lordship. That is, we have filed
That's-
contempt also.
Ms. Zimomi, please, please. Yes, you tell us what have you done?
We have filed contempt also.
Your statement is on record. You have said that the process is on.
Lordship. Contempt has been filed.
Therefore, any delay would be detrimental for you later.
Yes.
All right.
There is already a contempt proceedings going on.
On that day, we shall finish it off because those appointees whose appointments have been quashed, they can't continue forever because there is a time limit.
Exactly, Lordship.
And then with this, with the pendency of this appeal, which has got, I mean, prima facie no legs to stand now, not on merits, but because it has been rejected by Supreme Court, the SLP. So we can't possibly do anything. And then, I mean, if the process is not complete, your state would be in difficult position with no policemen to man the law and order. Do you realize this?
Yeah.
So therefore, you should come up with something more concrete. Yes, they are, Mr. Saikia would be justified because they are the appointees whose appointments have been quashed. But then they were there before the Supreme Court.
Exactly.
Lordship, that is the problem.
No, any one of them. But judgment in whole.
Yes,
How
Lordship.
do we?
Those who were not, anyway, Lordship,
The underlying portions. I mean,
both
why do
the-
you have to advise your assisting counsel?
Lord.
Nothing can be done. Otherwise, we would have heard it.
I know where I stand, Lordship, in this case.
All right, after 3 weeks.
Lord,
22nd October,
deeply obliged.
up to item number 7.
For hearing, Lordship.
What is it?
We are only looking for some concessions like whether we can participate in this, all this. I'll make my submission on.
No, that also has been decided by the judgment.
Exactly, Lordship. Exactly.
Limine dismissal, Lordship. No,
No. Supreme Court in limited.
in limit.
So therefore, the order attains the single judge's judgment.
So
attains
for a
the
judgment is,
final.
yeah, that is final. Maybe, Lordship, because some may be overage, all the certain issues.
We can't make.
Understood.
We
Lordship.
can't even make a
But
single.
go to Supreme Court also, actually, this is the
You
route.
should have come in
They
appeal.
have bypassed this route. They,
You should have
actually,
been appeal.
the Honorable Supreme Court, in my humble submission, they should not have gone there. They should have come through this channel and within
That's
the
it.
interest.
So therefore, I mean, we are only asking you to
Yes.
tell us whether it is required to go through all this. Now, even this petition, I mean, this can.
Let them understand that.
Lordship, one submission, please.
Yes.
The condemnation may be delayed, and in the next October, hearing may be taken up, Lordship.
Yes, October. All right.
22nd October.
Deeply obliged.
We give you not 3 weeks, we give you 2 weeks.
No difficulty at all.
All right.
Item number 8.
Obliged, Lordship.
Yes.
May I please it may.
Yeah.
So, Lordship, in this case, Lordship, I have challenged the Honorable Single Judge order dated 26/11/24, Lordship. Annexer D, page number 73, Lordship. Lordship, wherein Honorable Single Judge has rejected, dismissed my petition that this present lead petition has been filed as because the respondent number 4 has been appointed for the post of head assistant, Lordship, under the district establishment of Dibrugarh, Lordship. Accordingly, government has issued the appointment letter to the respondent number 4, Lordship. Order dated 22 to 2023, Lordship, the said order has arising out in pursuance of advertisement dated 25/5/2022, Lordship, Annexure C, page number 39, Lord. In my original writ petition, Lordship, that is the advertisement, Lordship. Page number 39, Lordship, can you come?
No, actually, you argue, we have seen that.
Yes, Lordship. The said advertisement itself, Lordship, that is the criteria fixed and framed by the advertisement itself, Lordship. May I please to read the advertisement, Lordship? It is
Yes.
25/5/2022.
Yes, that
In part,
appears to have been quoted in the judgment, isn't it?
Paragraph 13.
yes, Your Lord. So in pursuance of government approval communication by letter number so of the Commissioner Upper Assam Division Jorhat application in standard form as prescribed in the first page of part 9 of Assam Gazette are invited from the intending candidate for filling up to one temporary of head assistant in the amalgamated establishment of Deputy Commissioner of Dibrugarh in the pay band of fee of rupees so grade pay rupees so plus other allowances as admissible under the rule framed from time to time. Candidates who have not completed at least 10 years of service at senior assistant, including supervisory assistant in different branches of the amalgamated establishment of the Deputy Commissioner in Assam, not need to apply. That is one of the prescribed conditions prescribed in the advertisement itself. But the same prescribed condition has not followed by the respondent number 4.
In what
Even
way?
me, Your Lordship.
In what way? Why has it not been followed?
Lordship, that is why, Lordship, without fulfilling such condition, Lordship, the government has appointed the respondent number 4 for the post of head assistant, Lordship, had government order dated
No,
20
So
February
therefore, are
2023.
you saying that respondent number 4
Yes,
was not confirmed in service and therefore she could not have been considered?
yes.
That is one.
That's one. And the other?
Under which-
Other ground is that, Lordship, that is the rule prescribed itself, Lordship. In the Ministerial District Establishment Service Rule 1967, Lordship, page number 194, Lordship. That is categorically mentioned, Your Lordship,
Paragraph 14.
in section 6, Lordship.
Endings.
May I please to read, Lordship, that recruitment to the service shall be made by the appointing authority according to the procedure laid down below. Sadar Head Assistant, Subdivisional Head Assistant, by selection from among a senior assistant with at least 2 years of service as such to their credit, including supervisory assistant in concerned Deputy
The
Commissioner
word used is
establishment.
including. It is not exclusive, it is not and, including, it's inclusive.
Yes, Lordship, including.
So therefore, a candidate having 10 years of service as senior assistant would also be eligible for the post of head assistant or supervisor assistant, all that also.
Yes, Lord.
So you say yes, so why do you challenge this judgment?
But Your Lordship, the respondent number 4 who was appointed for the post of head assistant, Lordship, she is junior than me. Even, Lordship,
That doesn't make any change
her service was confirmed, Lordship,
later.
later than me, 9 years back, Lordship. That is the rule itself says that, Lordship, 11 seniority, Lordship, sub rule 6. May I please to read, Lordship. If
Yeah.
confirmation of the member of service in cadre is delayed on
Sir,
account
you don't
of
have a
which.
case. You don't have a case now. Later.
But Your Lordship, Honorable Apex Court is very much clear that the basic criteria should be fulfilled, Lordship. That
There
is the
no
basic
question of
criteria
following that.
mentioned in advertisement, Lordship. That is eligibility criteria for government jobs cannot change midway, Lordship.
Who appears for respondent number 4?
I'm for responding for you.
You're Mr. S. Datta.
Yes, sir.
All right. For other respondents,
State. One minute.
there's no appearance. Take. We have heard Shri Mintu Saikia, learned counsel for the appellant, and Mr. S. Datta for respondent number 4. There is no appearance on behalf of the other respondents. The judgment of the challenge is dated 26th of November 2024, passed by a learned single judge in WPC number so-and-so. Pursuant to an advertisement dated 25/5/2022 for filling up the post of head assistant in the establishment of Deputy Commissioner Dibrugarh comma, the appellant and others had applied, but respondent number 4 was declared to be successful. The appointment of respondent number 4 on such post was challenged by the appellant on the ground that she was wrongly considered for appointment, as in the terms and conditions stipulated in the advertisement, a candidate who would not have completed at least 10 years of service as senior assistant, including supervisory assistant, in different branches of amalgamated establishment of the Office of Deputy Commissioners in the state of Assam would not be permitted to apply for such post. It appears from the records that it appears from the reading of the terms and conditions of advertisement that the eligibility condition was only of a candidate having 10 years of service as senior assistant or as supervisory assistant in different branches of the office. The terms and conditions do not specify that for a person to apply against such advertisement, he/she has to be a supervisory assistant as well. There is no denial of the fact that the respondent number 4 had the requisite experience as a senior assistant. An objection was raised that respondent number 4 was junior to the appellant, which objection has no legs to stand, as it is a case of fresh appointment on the post of head assistant, where all eligible candidates, senior or junior, would have appeared if the eligibility requirement were fulfilled. The other objection raised on behalf of the appellant before the learned single judge was that the services of respondent number 4 were never confirmed, which was found to be factually incorrect. The services of respondent number 4 were confirmed in accordance with Assam Ministerial District Establishment Service Rules 1967, which permits confirmation with restoration of seniority even beyond the specified period, provided other conditions are satisfied. The facts on record indicate that services of respondent number 4 was confirmed, though later. In that view of the matter, there does not appear to be any basis for the appellant to challenge the appointment of respondent number 4. It further appears from the records that 4 persons were recommended for selection. One, MS Malti Barua at serial number 1, the respondent number 4, the respondent number 4 was placed at serial number 2, and the appellants, are there 2 or 1?
2 appellant.
2 appellants.
Appellant.
How many appellants?
1 appellant.
Lordship, 1 appellant, Lordship.
And you were at serial number?
3, your Lord.
And appellant was at serial number 3. Another candidate was placed at serial number 4. Because of Srimati Malti Barua having withdrawn her candidature because of her selection to the post of Siristadar, the respondent number 4 was highest in merit, and so she was selected to be appointed on the post of head assistant. The learned single judge has rightly analyzed that the eligibility condition set out in the advertisement dated 25/5/2022 does not specify that only such candidates would be allowed to appear for such appointment who would have possessed the experience of working as supervisory assistant in the amalgamated establishments. If a candidate had at least 10 years of service as senior assistant also, comma, he/she would fall in the category of eligible persons to apply. In the present case, respondent number 4 had the requisite experience and she was placed higher than the appellant. In that view of the matter, comma, there is no reason for us to interfere with the judgment of the learned single judge, whereby the challenge put up by the appellant therein was rejected. There is no merit in this appeal. The appeal is dismissed.
Item number 9 to 12.
May it please your lordship.
Yes.
This is a bunch of cases related to the cooperative society. And more specifically for item number 11.
Item number 11 is Jishu Kumar Nath.
Dishu Kumar.
Who is he?
My lord, I was a secretary of a registered cooperative society. The board on a meeting decided me to remove me from the post. And I went for an appeal under the provision of the.
Are you appearing in all these matters?
No, but I'm appealing for number 11 and my friend is for the cooperative society.
Let us hear this statements.
My lord, must.
Yes.
The register of cooperative societies, my lord, have filed 2 appeals, my lord. And in fact, here, my lord, what has happened by the impugn judgment, the part of the register of the cooperative societies, my lord, as by necessary implication, that has been obliterated. So therefore, the register of cooperative societies is before your lordship, my lord.
So therefore, that we have seen there are 2 judgments, one which has been impugned in the present petition. There is the other which is by another judge.
By the same honorable judge.
Or by the same judge. All right.
No.
So
Item 10.
what we do is that we hear separately
Item
each
10.
of these appeals. Now, first of Abhijit Chakravarti, where is he? Who appears for Abhijit Chakravarti? You started first.
May it please your lordship.
Yes. Yes.
But my facts are similar to which my learned friend has stated. But your lordship is called upon to basically, in my perspective, my lord, to interpret the provision of section 92. Lord, if you
Yes. Section 92.
my lord. Lordship, may I read, my lord?
Yes.
Any dispute touching the business of a registered society other than a dispute regarding disciplinary action taken by a society against an employee of the society or of the liquidator of shall be referred to the registrar for decisions if the parties thereto are among the following. So, my lord, under A, the society is past or present controlling or managing body, any past or present officer. So, my lord, I as a secretary would come within the purview of present officer, my lord, or past officer, or as an officer, my lord. Rest, my lord, not applicable to me, my lord. My lord, what has happened, my lord, that I was selected as the secretary, my lord, and I was terminated. I preferred an appeal before the registrar under 49(2), my lord. And, my lord, that matter was taken up, my lord, considered and decided. The society came up before your lordship's, my lords, contending that the registrar has no jurisdiction. But it was submitted that the jurisdiction comes under section 92 and section 111 of the Cooperative Societies Act. Which is appeal or review.
All right. So under 49(2), you file a petition before,
Yes, yes.
before
Let-
the joint registrar.
Before the registrar,
Registrar of the
My
Cooperative
lord.
Society. Come to 49(2).
my lord. The chief executive, my lord, 49(2) I'm reading, lord. Shall be under the general superintendent direction and control of the board and exercise the following powers of the functions, namely day-to-day management of the business of the cooperative society, operating the accounts of the cooperative society, signing the documents. But these are all, my lord, like
So L,
L.
49(2)L.
My lord, in case of dispute between the chief and the board in any manner, the decision of the registrar shall be binding on both.
So this is with respect to dispute. Dispute does
Yeah.
not mean removal.
My lord, may I indicate your lordship?
And the registrar passed an order reinstating you.
Yes, yes,
And the judgment says that no, it can't be done.
yes. My lord, the judgment has 2, 3 parts, my lords. But it says, my lord, there, my lord, the argument, my lord, went from that perspective, my lord, that section 49 was a wrong quoting of a provision. And if the registrar has a power, my lord, that would suffice. But that was the realm of the discussion, my lord. And my lord, interpreting 92, my lord, your lordships, the learned single judge has held, my lord, that the issue pertaining to the termination will not come within the purview of section 92 because of 2, 3 reasons, my lord. If your lordship would kindly have a look at 92 again, my lord. Any dispute touching the business of a registered society, relying of 2 judgments, my lords.
Other than dispute.
Any dispute touching the business of a registered society other than a
Other than a
disciplinary
Yes,
action.
sir.
So, my lord, the first part touching the business, my lord, the learned single judge has interpreted in my respectful submission,
You don't have to fold your hands. Just
No,
argue
no,
with that.
my lord, interpreted in a narrow, my lord, manner, relying on 2 other similar or provisions of Andhra Act as well as Maharashtra Act, my lord. But there the definition is little wider. My lord, I'll show to your lordship.
Let's come to that part of the judgment where this has been interpreted.
My lord, page 147, if your lordship comes, my lord.
Internal page of the judgment.
My lord, it's 29.
Yes. Read the paragraph.
Before that, the issue your lordship says, para 32, internal 27, it starts. On a close look at section 92, it is discernible that any dispute touching the business of a registered society can be referred to the registrar for decisions if the parties to the dispute are among those which are enumerated clause so and so. Section 92 has, however, carved out an exception in that a dispute regarding disciplinary action taken by a society against an employee of the society cannot be referred to the registrar under section 92 of the dispute. To examine the issue, whether expression touching the business of a registered society would take a matter of termination, removal of an employee of a registered cooperative society within its embrace, it appears apposite to refer to the decision of Honorable Supreme Court of India in the Cooperative Central Bank and others, reported in so and so. In that case, an industrial dispute arose between a number of cooperative central banks in the state of Andhra Pradesh and their workmen before the Industrial Tribunal, Hyderabad, and the subject matter of the dispute.
Now, why do we get into all this? When the terms of the section is
Yes.
absolutely clear.
My lord, your lordship kindly come to 147, section 61,
Section 61.
page 147, my lord, that has been quoted, my lord. Andhra Pradesh.
We have the act before us.
No, my lord, I am referring to the judgments.
Internal
Come.
base.
Internal page 29, my lord. Disputes which may be referred to the, notwithstanding anything in law for the time being in force, if any dispute touching the constitution, management, or the business of a society,
Other than.
other than a dispute regarding the disciplinary action.
Then what happened? How has the court said?
But again, relying on the other judgment, which your lordships find of Deccan Merchant and page, internal page 30, my lord. And para 35, I'll straight away take your lordship to page 150, the other provision, my lord, which has been relied upon. Your lordship has section 91, my lord.
Paragraph 36.
Yes, 35.1 at internal page 32.
Is it from to the 36?
I'm on section 91 of the Maharashtra Cooperative Act, my lord.
Now come to paragraph 36.
Yes. From the aforementioned decision which have been rendered by interpreting a statutory provision in the concerned statute governing cooperative provisions substantially similar to section 92 of the 2008, it is clearly evident that the expression business is to be considered in a restricted sense, and the expression business is to be construed as and means the actual trading or commercial or other similar business activity. The cooperative society is authorized to enter into or under the relevant statute, the rules and its bylaws. It has been held that the expression touching the business of the society would not cover the service disputes pertaining to the employees of the cooperative society. It has been authoritatively held that the service disputes between the employees of cooperative societies and the management of the cooperative societies do not come within the purview of disputes touching the business of the society.
Now come to paragraph 38 now.
My lord.
This is the finding.
Yes.
This is the interpretation.
In view of the above exposition, it is clear that a service dispute between the employee, like the chief executive secretary of a cooperative society, who is a full-time employee of the cooperative society, and the board of the cooperative would not come within the purview of a dispute touching the business of the society appearing in section 92.
Therefore, excluding the jurisdiction of the registrar to get into all this.
Yes.
Correct?
Yes.
So is what is wrong about it? From the plain reading, there may be very small difference or big difference between different
So far as
cooperatives act. But then section, let us leave aside all such comparisons.
yes, my lord.
Now, if we read section 92
My lord.
of the Assam Cooperative Societies Act, is it not very clear?
Well, that's why I was making it.
The business, unless you read section 49 in a big
The
way.
problem lies somewhere else, my lord.
No, this is first things first. You deal with
That's
this.
why I am
You
comparing.
deal with this first and we'll.
Yes,
come to
yes,
the
my
other
lord.
one.
That's why a comparison is required, my lord, and your lordship has to, my lord, interpret.
No, we are not going on that logic at all.
My lord.
We are on a plain reading of section 92. So therefore, we do not find any enabling provision for the registrar to enter in this arena. If it is a service dispute. No, you were appointed as a secretary, you were disengaged.
Dismiss, yes. There's no dispute as regard that. But the registrar has a big wider problem because of what I am making a submission. my lord.
Yes, please make your submissions. So therefore, please do not harp on these two judgments saying that the acts are different. No, we are not referring to that.
My lord, my submission would be, my lord, what the other part is, my lord. There are two aspects, my lord. First, it doesn't include. Second, it is a disciplinary action. So registrar is out of the purview. The third aspect is, my lord, that is a contract. My lord, the learned single judge has gone to the extent, my lord, saying that it's a contract determinable in nature, my lord. So that was not the scope within which, my lord, it could have been, my lord, decided.
So if 92 is not the provision
Yes,
for you to have approached the registrar,
my lord.
then would you be rendered remediless?
We just severium that has been done, my lord. That's why I'm coming to section, my lord.
49.
No, my lord, I am coming to section 110,
110 of what?
my lord, 2007 Act.
Act, 110.
Yes, my lord.
111.
110, my lord. Bar to jurisdiction. Save as provided in this act, no civil or revenue court shall have any jurisdiction in respect of a so-and-so, so-and-so. C, your lordship would see any dispute refer to the registrar. Section 92, my lord.
This is in tune with 92, no?
Lord, that's correct. So, my lord,
It is in tune with 92.
My lord.
92 says what can be referred to the registrar.
yes,
So unnecessarily civil court should not be burdened with that.
Absolutely, my lord.
Liberty.
Lord, that's why, my
This is, in 92 service dispute is excluded.
lord. Lord, what I'm saying now, I have a,
You don't even need to go to service. You could have straight away come to High Court under Article 226.
Lord, I cannot, because cooperative society has been held that it's not an instrumentality of state under Article 12.
See, there are.
Lord,
two
in this
things.
judgment itself.
No. We'll read it
Lord, I
differently.
have not come before your lordships.
We have followed that.
Yes.
Therefore, with the provision, we have followed that. We are just.
And
want to
just
take argument,
point of
See,
information, my
two
lord,
aspects of the matter.
my lord.
Now, there is essentially no difference between a body created by a statute and under a statute. Both would come within the state.
My lord.
But there are some bodies, the third kind,
My
which
lord.
are governed by the statutory rules. And depending upon what is the nature of what is the nature of the presence of the state in that body, it is
My lord.
decided whether it is state or
Yes,
not a
yes.
state. right?
Pervasive control, my
So
lord.
even if a body is considered to be a state, it may not be foisted with such responsibilities which are generally foisted on a
Yes.
state.
My lord.
So therefore, the reverse logic also would apply. Correct. So this discussion may not be very relevant whether you are whether you come within the definition of state or not state for a writ jurisdiction to lie.
My lord.
That comes later. We will decide about it later.
My lord.
Presently, we have been called upon to see whether the court, the learned single judge, was wrong in deciding
My lord.
that this dispute could not have been decided by the registrar.
My lord.
What arguments have you to advance? You please tell us.
Yes. Lord, my interpretation, Lord, my submission for your lordship's consideration is this, Lord. Because, Lord, there are other issues, Lord, which state may also raise, Lord. Lord, I am on that. Lord, in generally what's happening, Lord, even in election of a cooperative society, Lord, reports are, Lord.
Let us leave all such powers.
No, Lord.
Disciplinary, there was a FIR registered against you.
My lord.
Even before that, there was a complaint.
Yes,
And then the board of directors met and they chucked you out.
yes, without giving notice and all, that's on the.
Notice is required under different circumstances. What notice is
No, I'm
required?
not on the merits, Lord, I'm on the jurisdiction part of it.
Jurisdiction part. So you limit your argument to this.
But my submission for your lordship's consideration is this, Lord, and I have got alternative submissions also. Lord, the business of the society.
And notice again will fall in that category. The argument that it is not a state, therefore no notice. You are not a civil servant. You are not a government servant, therefore no notice. So these are all allied aspects.
Yes, yes. But my submission for your lordship consideration is this, my lord, that the dispute touching the business of the society so far as 2007 Act has been interpreted in a narrow way, because unlike the other cases, my lord, there are other things which has also been included in the provision law. So it has to be given a wider meaning than the narrow meaning that has been
No,
given by
wider
the
meaning-
learned state.
Giving wider meaning is not a difficult job.
My lord.
Because if what the powers and functions of the chief executive, which in this case is the secretary of the board,
My lord.
is defined under section 49.
Yes, my lord.
So if this proscription in specific terms under section 92 were not there,
My lord.
we could have considered it as one of the powers.
Yes, yes,
Just for carrying out the business of the board.
yes, yes.
The registrar or the secretary, not registrar, the secretary has to be employed, has to
My lord.
remain engaged with the board.
But 92
So
also says
therefore-
past or present officer.
That's all right.
But the
That-
second part, the disciplinary part
No.
perhaps throws me out of the contention
No, no.
of 92.
Now, let us not deal with facts.
My lord.
Now, the law is very clear. We could have read it widely
My
and
lord.
no narrow restriction we would have put. Unless this prescription were very clear. We could have said that any business which cannot be done if the secretary of the board is to take all decisions, convey all decisions, decide, maintain the office
lord.
book, and if he's chucked out, then perhaps it touches the business of the board. But in this case, because section 92 is a specific provision with respect to the jurisdiction, to the exclusion of all others. Suppose this exclusionary part,
Yes, yes.
exclusionary part under 92 were not there.
my lord.
We could have read it in the wider sense
Yes.
as defined under 49.
And I'm further perhaps excluded because of the disciplinary angle incorporated in that.
That's right. So not on account of any other fact, but for the reason that there was a complaint and or within 2 months only you were checked out.
Yes.
So it was with respect to the FIR.
And Lord, the other observation, Lord, that it's a contract of Lord, service or contract for service, Lord, if this exercise has to be done, Lord, that was not within the scope of the list that was placed before your lordship, Lord.
Except where otherwise expressly provided.
So therefore, sir, April will not.
No, provided.
This has also been interpreted.
This is not. Then 11 को कहाँ से this is? Why?
Not necessary.
This is with respect to 19. No, appeal or review, there is no provision, no, because this is a decision by the board.
Lord, I'm on 110. If I have no remedy under 92, I can go to a civil court, Lord. And for the state, there lies the problem, Lord. What has happened? Because of narrow interpretation, Lord, there are issues of election management, all which are decided by registrar and against which writ petitions are filed before this Honorable Court, Lord. Or Lord, if a narrow interpretation is done, except for the
The argument which you will advance is this,
My
I
lord.
mean, which I would have advanced,
My lord.
say I were a lawyer.
I am
I would have
obliged to
said
you, lordship, Lord.
that no person can be rendered remedy.
Yes, yes, that is our,
So therefore, under 49,
my lord.
if it is not under 92 and not under 111, where do we go? And you are holding the cooperative body, the cooperative society as not a state, and therefore no 226.
My lord,
And with 110,
my lord.
barring all such matters which would go before this, nothing. So therefore, the essential argument in this case would have been the validity of section 92 and not your facts.
Lord, I am obliged to your lordship, Lord, but I am coming in the appellate stage only, Lord. No, only
That
my
you cannot do.
difficulty. Yes, yes.
So if at all you were interested for future, you could have challenged the correctness of the provision exclusionary clause in section 92. Otherwise, what do we do?
But so far as my,
So therefore,
my lord,
you went before the registrar, registrar's order was challenged before this court. You're in a cat 6
Yes, yes.
situation, no doubts about it. Civil court, you cannot go.
Lord, if your lordships interpret that way, perhaps my route would be open under section one.
So, Can't go to civil court, yes, it be interpreted that way. So that you can always,
Lord, if that interpretation remains, Lord, that would also lead to several other litigations.
But
Lord.
option is, take a judgment from us and you approach the civil courts.
Yes, no, that route, if open for me, Lord.
That route is always.
Yes, yes, no, that's why I'm saying, Lord, if that interpretation falls, Lord, I have the alternative.
No, but suggest any other interpretation which is acceptable to us. I
But-
think it's.
But still,
It's
Lord,
fine.
I'll pursue your lordships, Lord, to give a due meaning to the business of the,
We have said that. How many times will we say this? Business is defined under 49.
but because there are other connected, Lord, if narrow
Like
interpretation
this,
is done,
which-
Lord, like election of a member, that issues is, Lord, referred to registrar. So if it's only as regard the commercial business, Lords, that this will again be excluded and that will a flood of civil cases, Lords.
But your case falls completely under the exclusionary.
Yes, Lord, if that can be, Lord, that if you Lord,
How to read it down? Can we read it down in any possible manner that you can think of?
so far as I am concerned, Lord, if that interpretation is given and remedy of civil court is available to me, Lord,
The single judge has said so.
Paragraph.
no, Lord, it has not been indicated. Lord, it says, Lord, that since the contract, Lord, no,
Where is that?
my Lord,
Where is that?
Well, para 47, if your lordship see is page 42.
Para 47, yes. Para 47 doesn't answer to that.
Yes,
Now
my lord.
we're coming to the summation of the judgment. Starts
Yes.
from para 72,
My lord.
or maybe even before that.
Para 71.
But these observations, my lord, will not help my case, my lord.
Why not? There is no
No.
prescription in the judgment that you can't go to.
That it's a contract determinable in nature, but these were not the issues that has come before the learned single judge, my lord.
We can, it's a continuation of the writ proceeding. We can say
Or
that
your lordship may say, my lord,
we will definitely take it into account that a person cannot be rendered remediless, so
Yes.
you can go there.
or my lord, if I approach civil court, my lord, it should not be clouded, my lord, with the observation.
We can't blow hot and cold, no?
No, my lord, my submission for your lordship's consideration.
We have followed you. So you don't say, I mean, even if we don't say that, you have an option open before the civil courts.
That observation will not, my lord, come in way in deciding that issue.
Which observation?
The contract of mine is determinable in nature, and my lord, other observations have been made.
What observation? Tell us.
I'm looking at 54. We're gonna keep 53. You think of it, is it in the 53, like, it's a more contract person.
Given that should be decided by the civil. Oh, sir, it's a contract. No, 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 a point one for you.
They have existed discontinued family.
Which paragraph? Tell us.
51, I think.
No, these observations are. The court was not called upon to decide this.
Yes, no, that's my lord, my submission.
Then we don't agree with this proposition.
And therefore, my lord, and for there is totally in different realm, my lord, when we contract for personal service and all, my lord. So, my lord, if I approach civil court, my lord, I should not be, my lord.
When in paragraph 52, when the learned single judge is referring to the powers of the court.
Yes.
Court would not give a declaration that the contract subsists. That is, it is limiting the powers of the civil court. The single judge cannot do that.
Yes, that's.
That 53. Then paragraph 57.
Para 57 and 58, if your lordship sees.
58 also.
This is with respect to the powers of the board.
My lord.
Powers of the board is all right, but who prevents you from going to civil court? And there is
58,
no
my lord,
such finding also. It
cannot
may
be
be a
specific.
contract, it may be anything. I don't think so that you need to fear and apprehend that when you approach the civil courts, should you like to do so, you would be prevented. No, I don't think. I mean, there's such a. Not at all. Then a person will render remedies. Whichever is the situation. It's written State Bank of India and others were S.N. Goel. Just a minute.
About 64 also.
a specific relief act. According to these judgments, he can only go for damage. The judgment should not have. And therefore the order is long as. Or we can say that the one that rules it. This we cannot order.
And that is noticed by the possibility.
The other 2005 for SCC, 649. These deliverables. Four S6. 649. That is governed by the cooperative societies there. I think even though it is not a state with the minimum Article 12, red jurisdiction. Now we are of the view that the writ jurisdiction would lie. But then here it is not going to help
Yes,
you
yes.
because
I'm a respondent. to that. At least it open up a forum for remedy for me.
We entertained writ petitions against Cricket Club, Board of Cricket Control of India. We have been entertaining applications.
Federal Bank also.
That's the reason.
The accounts of the society are also audited. The registrar has a control over that.
Control, yeah, that's control. It can only distinction is an exclusion to the department. That is by schedule.
We will not be required to answer that. We can, while we can make an, that will be an obiter.
My lord.
You are not rendered remediless. You can always go, I mean, even with respect to the section 14 of the specific relief act.
That is perhaps my response submission is for contract for off service. So that will not come within my purview. For special knowledge, I am having specific, this is not my case, whether specifically enforced or not. If I would have raised that issue as a petitioner, perhaps not the learned single judge could have looked into it. The society has gone before single judge on the issue of jurisdiction part only. So these were not the issues to be determined.
All right, but this judgment is sustainable, no? So far as you're concerned.
Yes, so far I am but that will not give me a window under 110
Let's see. Yes, who appears in this matter for the other side?
Deeply obliged.
All the issues are same. If you're not, at the last year, lot and hear him, my lord, because his submission will.
All respondents are the same.
Yes. My lord, may I address your lordship from the perspective of the registrar?
State.
Yes. My lord, in fact, if I can satisfy your lordship, my lord, that there is a source of power under the act, whereunder the registrar can, my lord, intervene in the matter of appointment and removal. Perhaps your lordship will uphold his jurisdiction, my lord, and overrule the judgment of the learned single judge. Now, irrespective of 92, my lord, if I take your lordship, my lord, to the paragraph 72 of the learned single judge, whereby the learned single judge has held, my lord, this is the operative part of the judgment, my lord. My lord, there is a reason why I'm taking your lordships to para 72. And certain other provisions of the act, my lord, has been mentioned by the honorable single judge. Page 87 of my petition, my lord. Item number.
Internal page.
That's internal.
Yes, internal page, my lord, 63.
Yes, we are at it.
Yes, para 72. Summing up, this court has found that the registrar appointed under section 3, your lordship will kindly take note of section 3 of this 2007 Act, either by section 4912 or by section 92 or by section 111 of the 2007 Act, has not been vested with any power, authority and jurisdiction to decide on any decision taken by a validly constituted board of a registered cooperative society, either in the matter of appointment or in the matter of removal of the chief executive secretary of the society, a full-time employee appointed by it. As such, the impugn order dated so-and-so passed by the register is unsustainable in law. Now, here, my lord, the honorable single judge has omitted to refer to section 45. This is another section which I'll come to your lordships, my lord. Now, before that, what I would hasten to add, my lord, that in respect of each and every appointment and removal, the board has to take a decision, my lord, a resolution, my lord. And unless that resolution is approved by the registrar under the act, my lord, it will not take effect. So therefore, whether it's a resolution in respect of other issues or is in respect of appointment or removal, my lord, the approval by the registrar is sine qua non.
Suppose all right, yes.
So therefore,
Now, for that, it has to touch it, the decision of the board has to touch the business requirements.
no, my lord, because section 92, in my respectful submission, my lord, is independent of section 45 and 111. Under section 45 and 111, the source of power, my lord, the supervisory power of the registrar
Let's
is.
see section
Yes,
45.
before that, I take your lordship to section 3, my lord. The object, my lord, of the object and purpose of appointment of the registrar, section 3, the registrar, the state government may appoint an officer to be the registrar of cooperative societies for the state or any portion of it for registration, supervision. Your lordship will kindly take note of supervision, assistance, counsel, and for all-round development of the cooperative movement in the state with such other powers and responsibilities as may be provided under this act or rules or bylaws framed thereunder. So inter alia, my lord, the power of the supervisory power in respect of, my lord, the entire management of the cooperative.
That argument, the whole premise is incorrect, Mr. Talukdar. See, when there is a specific provision, the general provisions give way.
Correct, my lord. Now I'm coming to section 45, my lord. 45 says that the resolution adopted by the board has to be sent to the registrar. And within 15 days, he has to approve it. Meaning thereby, my lord, the power rests with the registrar to disapprove also, my lord. Every cooperative society, if your lordship comes to 45 of the section 45 of the act, every cooperative society shall record in the minutes book in the official language of its station or in English or in any other language prescribed in the bylaws, proceedings of every general meeting, delegate general body meeting and board meeting, and the names of the members of delegates present thereat and shall be confirmed at the same or the next meeting. The proceedings of all the general meetings, special meetings of every cooperative society, complete in all respects as provided in the act and bylaws, shall be sent to the registrar within 15 days from the date of completion of such meeting with due acknowledgement. The registrar shall give his approval on the resolutions within 15 days of receipt of the proceedings. If no approval is received within the aforesaid period, the proceedings shall be deemed to have been approved. Now, my lord, my respectful submission, my lord.
Yes.
My lord, my respectful submission is the power of the registrar under section 45 also includes, my lord, the power to disapprove the proceedings of the board.
You show us any judgment. It has not been provided because if there is no approval for 15 days, it is deemed approval, not deemed rejection. We are afraid whether that interpretation is correct. Otherwise, it would have said that if no approval comes, it would be deemed to have been rejected.
My lord, in that context, my respectful submission would be,
Show us a law.
no, my lord,
Show us a law
interpreting
that under,
45.
under the Cooperatives Act.
Yeah.
If approval of most of the cooperative societies would be governed by the same kind of laws.
Yeah.
All acts of different states are similar.
Correct.
Only the number changes. Now, the registrar would have nothing to do with disapproval because he doesn't know, he doesn't have the powers of disapproval.
No, my lord,
He has to approve because the purpose is the expansion of business or carrying out of the business, ease of business, and he has to keep the records. He's the custodian of all records.
my lord, my respect.
But what a general body or a special body decides, can he go against? What power he has?
No, including the board meetings, my lord. In fact, the appointment and removal are taken in the board meetings by the board.
Come to 49.
My lord, I understand your lordship's query. My lord, can I put it in this way? If we accept, my lord,
Now
that,
let us see where the powers of the registrar
my lord,
has been defined.
registrar's power, my lord, is specifically not defined, but
Just a minute. Read three, the state code of for supervision, registration, assistance, counsel, and for all-round development of the cooperative movement. Otherwise, it does not remain a cooperative society.
my lord,
Registrar is only for the registration of the body, supervision, assistance, counsel, and for all-round development.
it is for the cooperative societies, my lord, for each and every, my lord, resolution by the board. My lord, the resolution has to be approved by the registrar. Otherwise, my lord, it will have no validity in the eye of law and it cannot be acted upon.
That's all right.
Correct.
That is because of the statutory obligation.
My lord,
That it has to be, no, we are asking something else.
Ma'am.
Suppose, does he have the power to disapprove also?
correct, my lord. My respectful submission is, if we, my lord, interpret that section 45 does not include the power of disapproval, then it is amounting to obliterate, my lord, the supervisory power. And thereby, my lord, the registrar would be rendered a mere post office, my lord,
Forget
in my
about-
respectful submission.
General propositions. Now, suppose a resolution of the board. Supervisory board, it can suggest, it can counsel. But suppose a decision has been taken and he does not, because otherwise, this section is very clear. For the non-approval in black and white, for 15 days, it is deemed approval. It should have been said deemed disapproval.
Correct, my lord. We have to understand in the context, my lord, with all respect.
Shows a law, it must
My
have.
lord, in that case, my lord, I'll get back to your lordships with the decision, my lord. But so far as my understanding goes, if we accept the proposition that, my lord, section 45 excludes disapproval, with all respect, my lord, my humble submission is that is amounting to make, my lord, the
Emasculating the powers of supervision.
absolutely.
Therefore, we are saying that you have to read section 3 more carefully. I mean, we have to read it more carefully.
My lord,
Yes,
correct.
you have every right to advance your arguments. The state government can appoint an officer of the registrar as a registrar of cooperative societies or any portion of the register for the state or any portion of it for the one purpose is registration, the other is supervision, third is assistance, fourth is counsel, and for the all-round development of the cooperative movement in the state, with such other powers and responsibilities as may be provided in the act or rules or bylaws. So the powers have been defined.
Yes,
So
And
these are the basic purposes.
Correct.
And now, with respect to the linkage between the board and the resolutions of the committee, all the resolutions have to be approved. If not approved, it will be deemed approval. Disapproval is not conceived of.
correct, my lord. But my respectful submission is,
Otherwise, have you ever seen any decision of the registrar whereby some resolution of the government, of the board has been disapproved? Otherwise, the board will stop functioning.
My
I
lord,
mean,
the-
where would the cooperative society
My
go?
lord-
The board will go where?
my lord, the registrar has to be fair and reasonable, my lord. On each and every, my lord, decision or resolution, he cannot interfere or he cannot disapprove.
You know what?
My lord, he has to be reasonable.
This source of, we are not finding this source of power here.
My lord, if your
Unless you
lordship
give us
goes through the entire provisions of the act, your lordship will find, my lord, the power of the registrar is all pervasive throughout the entire scheme. In respect of audit, in respect of closure, each and everything, my lord, all pervasive, my lord. So therefore, my respectful submission is, if, my lord, the supervisory power on the board is excluded, that is amounting to give an unbridled or an unfettered power on the board. Tomorrow, the board can take a decision which may be detrimental, my lord, to the shareholders or even the society.
Then on that,
My lord, on that count, I may
on
place
that-
judgment, my lord.
that count, we again come back to section 92. Again.
On the power of disapproval, I can get back to your
No,
lordship.
but why? With respect to the registrar's powers, we get back to 92.
My lord, 92, your lordship will kindly see, 92.
Source of power is located here. What you're looking for another source of power, which overcomes the exclusionary clause. Can we do that?
My lord, my respectful submission is, if, my lord, the interpretation of 92 is against the scheme, lordship has to read down.
Where is
Because-
the challenge? We'll read it.
No, my lord, your lordship, without the challenge, your lordship
No.
can read it down.
Who says so?
Because, my lord, there are Supreme Court judgments, I can place it, my lord.
You will not get any Supreme Court judgment where it is not, rather the judgment is that the court should be loath in deciding constitutionality of a particular provision.
No.
Unless it is specifically asked for.
My lord, if it is running contrary to the entire scheme, because my respect,
Where has it been put to challenge? We are in the appellate jurisdiction, we understand, it will be writ jurisdiction.
my lord,
This
this
is not
was,
challenge.
my lord, this was a case by the board. This was a case by the
You-
board.
you were-
My
you
lord,
were-
we did not approach your lordships, my lord.
You were going on a right direction, you were locating a source of power for the registrar to function.
No, your lordship will kindly appreciate, my lord. Under the scheme, the power, the supervisory power is all pervasive. Now, if it is obliterated in respect of the supervision on the functioning of the board, that is amounting to give an unfettered power, my lord, to the board. My lord, tomorrow the board can take any decision, my
What is
lord.
the purpose of setting up the cooperative societies? What is the purpose of keeping a separate department of the government for these cooperative bodies? Ministry of Cooperation. Why? It is one of the principles of directive principles of state policy to inculcate this.
Correct.
Now, therefore, registrar is only there for the purposes of registration and council. Is a government body, is a statutory body. That's all.
My lord, I respectfully disagree, my lord, because your lordship will kindly see, my lord, going through the entire provisions, my lord. Your lordship will see in respect of everything with regard to audit, with regard to closure, dissolution, right from, my lord, approving a resolution, my lord.
We have followed it.
Yes, the power is all pervasive. my lord.
Then we always refer to 92, which is very clear, a specific provision. What is it?
92 does not speak about who will refer, my lord. Because your lordship will see, 92, in my respectful submission, cannot, my lord, override or, my lord, obliterate other provisions, my lord, in respect of the supervision of the registrar.
No. What is that? No, I don't think so. I don't think so. What happened?
Now, the only door of the aggrieved party was the registrar, my lord. Now, this door having been closed, my lord, now the aggrieved party cannot go anywhere. And in under section 110, my lord,
That we will answer.
110 is a specific bar, my lord. My lord, may I place two decisions of the honorable court, albeit single judge?
We'll hear you after lunch. Just give us that decision. That power of approval includes within it the power of disapproval. It can be in other context, but it's not in Cooperative Societies Act.
Madam, if
General Clauses Act, my lord, will come into play. The power of appointment will include the power of termination also, my lord.
That is with respect to appointment. This is a completely different scheme.
Now, if we bring into, my lord, the analogy, my lord, the power of approval will also include the power of disapproval.
Let's see any judgment with respect to Cooperative Societies
Correct,
Act with the power of.
Correct, my lord. I'll try to find it out.
Analogy would not be apt.
My lord, if allow me, my lord.
Still deciding this in the manner in which you are asking us.
No,
to
no, my
give.
lord, no. We are,
But then
my lord,
we can't,
wait, wait.
we have to read the rules as it is.
When it is clear,
and your lordship will see,
General rules give way to specific rules.
my lord,
Generalia specialibus non derogant.
there is another provision section,
Generalia specialibus non derogant.
correct. My lord, there is another provision, section 9, with regard to framing of bylaws. Now, the bylaws, it requires prior approval of the registrar in respect of appointment and removal. Now, those bylaws are, my lord, framed under section 9, so having a statutory force. Now, in the, my lord, judgment, the honorable single judge, my lord, proceeds to hold that irrespective of a clause in the bylaw, that will not come in the way. So therefore, such, my lord, in interpretation, with all respect, my lord, is not in accordance with law.
The honorable judge meandered in a field where he was not called upon to do so. How are we concerned? We are only reading this power. We are locating the power of the registrar to decide a service dispute, a disciplinary dispute. That's the only thing. I mean, we are wearing blinkers.
Lordship, my friend, my lord, as regards, let the respondent complete after my submission. My lord, there is a vast distinction between section 92, 111, 110. They are very vast.
You are appearing for whom?
And for item number 11.
next.
On whose behalf?
For the petitioner, appellant herein, private respondent therein.
Okay.
My lord, I will make my submission equal.
All right.
I have not
Let
cleared
me
it, my lord.
complete first.
Yes.
And just make a note of his arguments. You need not repeat that.
My lord, I can place, my lord, I have made a written synopsis for the lordship's convenience, my lord. on your- I'll furnish a copy to my learned friend also, my lord. So basically, my lord, my arguments are what I would intend to argue.
Lekin these are also series. One series is there.
Where will go? We'll hear you after lunch.
Well, deeply obliged.
In the meantime, you also get that judgment.
I'll try to find out.
For 1 or 2 days, I'll have to rise intermittently because of the back pain which I developed while coming from Nagaland. Yes, it. I could lay my hands upon some of the judgments.
Yeah.
They say that the power of disapproval is there, but it is within those 15 days.
Right.
Beyond it, it cannot go.
Correct.
But that was by inferential logic. This question was not raised whether with this kind of wording of the section, where no response, no communication from the end of registrar, it would amount to approval. This question I didn't see. I mean, of course, I did not have much time to say, to see, but check it out.
My lord.
Yes, the other argument?
My lord, in fact, the other argument is in respect of section 111, my lord, there lies a power of the registrar, my lord, to intervene in the matter of, my lord, the appointment or removal. Now, if I take your lordships to 111, essentially it talks about, my lord, the government servant. 111, appeal or review. Except where otherwise expressly provided to the contrary, an appeal shall lie to the registrar from the decisions made under this act or rules framed thereunder by any government officer. My lord, this your lordship will take note of government officer, liquidator appointed under section 95. We are not, my lord, concerned with liquidator. So,
No, even government officer.
yes, my lord, in fact, what has happened, my lord, the power under 45 is delegated to ARCS by the government under section 3, subsection 2. Now, if the power by the assistant registrar is wrongly, my lord, exercised, then an appeal can be filed before the registrar under 111.
Okay.
So under such circumstances, my lord, the registrar assumes the power to decide the correctness or otherwise of the approval or disapproval by the ARCS, my lord.
No, but
So now, if I take your lordships, how this, my lord, 111 has been dealt with by the honorable single judge at, my lord, internal page 25.
I'll tell you one thing, all these matters, ARCS is no authority, no? Registrar is there.
No, section 3, my lord, subsection 2, if your lordship comes to subsection 2 of 3, my lord. The power of delegation is there, my lord. Lordship has got it, my lord. Subsection 2 of 3, subsection 3. The state government may also,
You have to read it in the context, no? So therefore he becomes a delegate.
my
So
lord,
he exercises all the powers of the registrar.
correct.
So therefore this 11 would not apply, no? He is the delegate
My lord.
and no extra powers could be delegated, but he would assist. I mean, that power would be amenable to challenge before another authority.
The power of review is also there, my lord. 1112.
Review is all right.
Yes. So he can review the order also, my lord, of the assistant registrar.
But 3.2 does not say that he is an addition because the recognition is of the power of the officer who has been designated as a registrar and to assist him many assistant registrars. So the power would be akin, analogous. The power would be analogous.
From the hierarchy, my lord, if your lordship says,
I don't think so. I don't think so. You can argue with respect to 111 surplus 2, but then this power does not have. Who would be the kind of government officer against whose
Order.
appeal or review would file? I mean, liquidator appointed under section 95.
that's a
would
different,
file.
that's a different
Who
aspect.
would be government officer? Any government officer.
Yes.
I don't think. Anyway, let's see.
My-
Which other provision?
Some paragraph you wanted to look.
You wanted to show some paragraph in the judgment.
My lord, the honorable single judge, my lord, proceeded to hold para 28 that appeal, my lord, is not an inherent right, it is a statutory right. And thereby, the honorable single judge, my lord, has held that under 111 there is no power of the registrar. But apparently, my lord, he can review or he can exercise the power of appeal of the approval or disapproval by the assistant registrar, any government officer.
He said
The expression.
that removal is not, jurisdiction is not one, but 111. In appeal.
So it is in the context of, analyzing that 111 does not clothe the registrar with the power to hear anything against
The
the
board.
decision of the board.
Board, correct, my lord. But when we understand the procedure which is involved in respect of, my lord, the deciding the correctness or otherwise of the approval, then the power under 111 comes in, man.
No, but I would be curious to know who this government officer would be with respect to cooperative society. What decision? Which part? Maybe the cancellation or something by somebody, by some authority, but it cannot be board at all.
It cannot be board, correct, no.
And it cannot be assistant registrar also because his powers are analogous. He would be entitled to hear review. Any government officer would not be an officer of the rank of additional registrar. Anyway, let's proceed.
Otherwise, there is no scope for any role of any other officer on that effect, because we are divided. How to under a scheme of that, no other role of any other.
That's right. So therefore either it is redundant or they, but 3.2 would only mean registrar.
Any delegate. Maybe it can.
But of the powers of responsibility. But in that case, he exercises the power of the registrar as a delegate. Same authority cannot hear an appeal.
Subsection 1 is delegated, but subsection 2 is not delegated. Triple 1 subsection 2. That power can be exercised by the registrar.
Master may review any order passed.
State government appoints an officer of the rank of registrar of the cooperative society.
Yes.
And the state government may also appoint any other person or persons to assist the registrar and maybe Indian. So any power,
And that too.
unless no, not under 2, but any power under the Act of 2007, which has to be dispensed with by the registrar, is also can be exercised by the additional assistant registrar.
When it's delegated to legislature.
So no appeal against the same authority. Anyway, we will look at it.
Yes.
This is your effort at locating the power.
My lord. In fact, under section 45, since your lordship has put a query, my lord, searching the judgments, I found, my lord, that this, my lord, dim approval is in the nature of a legal fiction. Lordship is aware.
Oh, I've seen that.
Yes, sir.
2001, Jagdamba Sugar Mills and all.
Yes.
Those are celebrated cases, but they don't say that with this kind of wording.
Yes.
The power to approve also inheres in it the power to disapprove.
Yes.
Or unless, what is the purpose of approval?
Yes.
Now, but it can be done only within 15 days.
Correct. And my lord, what I have understood,
By demean.
Then also, even if we accept this proposition, but the power is not, the source is not located for exercising this power. Because of 92.
Exclusion.
my lord, in my respectful submission, my lord, 92,
I'm not in a position, or I cannot overcome that.
yes.
You know, that's very, very categorical.
My lord, what has happened, my lord, in fact, I have got your lordship's query. I need to be, my lord, prepare
All
a
right.
little bit, my lord. So
We'll give you time.
some time may be given, my.
It's an important issue.
Yes, correct, my lord.
Before that, we will hear him.
Yes, because otherwise, my lord, what I understand, if, my lord, the door of the civil court is open, my lord, there will be, my lord, the floodgates of cases, my lord. Otherwise. Because here, everything is settled, my lord, by a,
No. Floodgate of cases, that also, see, the power is also limited. What is that power? What section? Which is that section? With respect to civil court, what cannot go before the civil court?
110, my lord.
110.
My lord.
Now come to 110. It's
Well.
limited, no? Any matter in relation to any dispute referred to registrar, civil court would not exercise jurisdiction. Any matter in relation to winding up.
Well.
In fact, most of the matters, they have taken it away from the ambit of AC.
My lord,
We'll see that over.
subsection 2, my lord, is categorical. Subsection 2 expressly provided, save as provided in this act, no order, decision or award under this act or working of the affairs of a registered society shall be liable to be challenged, set aside, modified, revised, declared void in any court or any ground whatsoever. So order, decision of the board, my lord, will also, my lord, will be inclusive, my lord. So there is a express statutory bar.
That's all right.
Whether your
So,
lordship will lift it, my lord.
Article 226. Z telephones.
Yes, I have to, my lord, go through those, my lord. I have to distinguish, my lord, whether a cooperative society, my lord, resolution of a board.
There are 2-3 principles which cannot be deviated from.
Correct.
Nobody can be rendered remediless, number
Right.
one.
Correct.
Number two, the act and statute have to be read strictly in terms of the wordings employed.
Correct.
And all possible steps should be taken to, to avoid making any portion of any statute.
Nugatory. Yes, redundant.
On these parameters, if we see that the only way out is 226. The registrar, not the registrar, the secretary of the board had the forum of Article 226 and nothing else.
My lord, then
That becomes very
against
clear.
any decision of the board, my lord, everyone will rush to the High Court, my lord, under 226.
That is no ground to read it differently, no?
No, what I'm trying to say, there
You
is a,
understand?
my lord, there is an in-house mechanism which is provided by the statute.
Not clear.
So therefore, my lord,
Therefore-
unless your lordship finds.
So Talukdar, you are perhaps missing on something because you're focused, and all of us are
Correct,
focused.
man.
This is the only way of talking.
Correct, man.
We are all focused on the location of the power.
Right.
But look at this, 110 is a bar to the jurisdiction of civil or revenue courts.
My lord,
The statute provides that just don't go to civil court.
my lord.
So all these matters, this would take within its ambit everything what happens in a cooperative society. The registration, dissolution, dispute related, refer to registrar or any matter, because all matters which the civil court cannot look at can go before the registrar.
Correct.
All issues, because every issue touches the business. Correct. So therefore, this is precluded. But 226, nobody can curtail the power.
Correct.
And this is the internal mechanism. I mean, prima facie, at
Correct.
least you can show it to us.
So
from
yes, Malak,
the judgment.
I'll try.
It would have-
Yes, I'll try
This
to.
issue would have been raised somewhere in some petition. I have not checked up whether those Jagdamba and others were referring to such cooperative acts of states which had similar provisions.
Yeah.
You'll see,
Right.
you also check up.
I'll try to,
What
Malak,
else- what
impress up.
else before, I mean, we'll not wind it up today.
Correct, Malak.
Let's see,
Yes, correct.
let's see.
I'm deeply obliged.
May it be pronounced. My lord, before I proceed with my case, my lord, I will place my facts a little bit backwards, my lord. Because facts,
Let us be on the law.
my lord, the law will depend on the facts. Two cases cannot be similar because the facts are
That's
different.
fine.
My lord, so
Now,
I will place a little bit of my facts. So your lordship will find out, because that will clarify section 92 does not include me. That I will place through the act itself, my lord. That is why I want to place the facts, my lord. I was a secretary. Then the secretary, by a meeting, the board decided to terminate me without hearing the other things. That resolution was placed before the register. Register approves it. Then it was challenged under the appeal under section 111 before the register, and which was taken cognizance by the register, and interim order of stay was provided. The other side, the present secretary and the other members approached the register and took time, and they came before this high court and obtained a stay order against the stay order passed by the register against my termination. That was the situation when the writ petition was there. I was made a private respondent as respondent number 5. I filed an application for stay vacating, and ultimately, because of the Bikrampur judgment, my judgment, because of the single judge referred the early judgment, and it was disposed of. But now what I want to place, my lord, the secretary in 92, if I read 92, my lord, your lordship may just, I will trouble your lordship to 92. May I read it slowly, madam? Any dispute touching the business of a registered society, other than dispute regarding disciplinary action taken by a society against an employee of the society. Who is an employee of the society, my lord? Let us take, my lord, I take your lordship to the definition 3S. I am a secretary. 3G deals with what is the definition of board. Board means board of director or governing body of a cooperative society, to which the direction and control of the management of the affairs of the society is entrusted to. That is board 3G. 3S. Employee means a person not being an office bearer, employed by a registered society on a salary or similar form of remuneration other than advance patronage, such and such. And now I take your lordship to 3X. What is office bearer? Who is the office bearer? Means the president, vice president, chairperson, vice chairman, secretary, or treasurer. So I am not an employee. So 92 does not attract me. Now I cannot be made remedialess only because on a decision of Andhra Pradesh and Maharashtra, where there is a tribunal and a court, there is a.
Just a minute.
Now I take your lordship to 35.
Just a minute.
My lord.
Office bearers are all, office bearers of the board, president, vice president, chairperson. vice
Secretary,
chairperson,
secretary includes
Secretary. Secretary also is an
office bearer.
Is an office bearer.
Office bearer, so I'm not an employee, my lord. And 92 reflects the employee.
The definition of employee is where?
Employee is 3S.
No, G.
3S is employee, my lord.
3S. is each board.
who not being an office bearer.
Mm.
And my lord, 35 is the board. What is the board? There shall be a board for the management of every cooperative society registered under this act. Is the management of that is the management of the cooperative society. And the function of the board is at section 38. Powers and functions of the board, 38(2). To nominate, elect, or appoint, remove the chief executive provided he is not a government appointee. I am not a government appointee. I am a chief executive of the cooperative society, who is the secretary. This is
So therefore the.
so
power
this
of-
is powers and function of the board means the business of the board. The business of the board under 110(2) is debarred from interfering by the civil code and the revenue code. So, my lord, every department is under control of the state. Every department has their statutory appeal. This is the appeal provided under the 111 under the Cooperative Society Act. So, my lord, then otherwise for every termination, there will be a writ proceeding without going to the appellate provision. I cannot be made remediless. No revenue court, no civil court. Before, if I go for a damage suit also, my lord, then also that has to be decided that particular termination is bad. That has to be decided by the civil court.
So what section 14 of the Specific Relief Act says?
14 is related to 41E. 41E say if it is terminable, 14C. But 14C will come into being. If it is determinable, then it will come because 41E related to 14C. Now, my lord, how?
Just
And now I take your lordship to 49L. 49, 2L. 2L, 49 2L. In case of dispute between the chief executive and the board in any matter, the decision of the registrar shall be binding on the board. So this is a dispute between the board and the chief executive. I am a chief executive. So this is the business of the board. Business of the board, there is a bar under 102. And there is a notification by the government. I have annexed in my writ petition, running page 171.
Has this aspect been seen by the land single judge?
Well, no discussion about 110, no discussion about office.
With respect to the definition of employee. and
No,
secretary-
I think, my lord, definition in Bikrampur judgment, my lord, I don't find. My lord,
Secretary to an employee, that's a strong argument that you read.
secretary is an office bearer. Is not an employee.
And
And disciplinary proceeding, my lord, subject to all my restrictions, my lord, I am a very small person. My lord. Formal action taken against an individual for misconduct, typical of a professional or organizational contact. The process usually involves an investigation, hearing, and decision on the appropriate cause of action. That has to be taken. So that disciplinary proceeding is there in 92 for an employee. In a meeting, if somebody throws me out, then I cannot be remediless. Like my lord, I cannot ask why and only to do and die. Like my lord.
liquidator is an employee, no?
Employee. The government employee.
Government.
Government.
Any dispute regarding veterinary act. Or
Motto 171. 71.
yes,
That is my whole.
main plank of argument.
My lord, 110(2), no discussion where I will go. And my lord, your lordship is well aware, with going down my head, my lord, I am just placing on the basis of Andhra Pradesh and Maharashtra, where there is a tribunal and a cooperative court. In Assam, there is nothing as such. There is no cooperative tribunal or cooperative court. In Andhra and Maharashtra, with the decision that was discussed in Bikrampur, have a tribunal and a court. So there is an alternative remedy. Where do I go?
All right, yes, who else?
Order.
Issue. Yes,
Yes, my lord. I am for the writ petitioner, my lord, which is judgment has been appealed, my lord. Your lordship will find in the section 45, whatever he says that approval of register is required. Approval of register is required only in case of AGM. Other board meeting, it is clear. Approval of register is not required. This is the answer, my lord. In respect of that approval of the register is necessary. Now, about the secretary, the employee, whatever he says, your lordship will find the answer is at 49(1). 49(1), answer is there, man. 49(1). There shall be a, may I read, madam, 49(1)(a). There shall be chief executive by whatever designation called of every cooperative society to be appointed by the board or by the state government. So they are office bearer, whatever the secretary we are getting, there is a secretary appointed by the government. Because sometimes senior inspector of cooperative societies are also appointed as a secretary of a society. Or junior inspector of a cooperative society also appointed. That secretary cannot be removed by the board. So this is the expression they have given by the act.
that's all right, but then he becomes an office bearer by virtue of the definition.
Of course, their definition in the employee.
He's appointed by the board, no doubts about it.
Yes, board, appointed by the board. Now he is getting some remuneration also.
This
So
is
49(2), my lord.
Mr. Sinha.
Yes.
So the another standard, don't just rush through.
Yes, my lord.
The another stand of argument is that if the employer has a right to terminate.
Yes, my lord. Yes, the employer is right to terminate. Who is the secretary appointed by the board, not by the government secretary.
Here, all are secretaries of the board.
My lord, here.
All are secretaries of the board here in these set of.
Yes, all are secretaries by the board, my lord. So he doesn't come on the office bearer, my lord.
Why?
No, because 49(1), he is appointed by, not by the government, he is appointed by the board.
How are you reading that? There shall be a chief executive by whatever designation called of every cooperative society to be appointed by the board or by the state government.
Or by the state government. So there is office bearer which cannot be removed by the board is a secretary appointed by the government. That cannot be removed. He is made the office bearer, my lord. Otherwise, employee, my lord. He's not an employee of the board.
Distinction we are not able to understand.
He's not the employee of the board. That the secretary appointed by the
moment he is an office bearer, the moment that he is, I mean, this is not by any inference. It says office bearer means a president, vice president, chairperson, vice chairperson.
Yes, my lord. Yes, my lord.
secretary,
Yes, yes,
president
yes.
of Society and includes any other person to be elected.
Here, it not expressed, it was not expressed, my lord, secretary or treasurer of a cooperative society.
Then the definition of employee says that he means any person not being an office bearer.
It's exclusion. Yeah,
Because he is appointed and he is not elected. He's not elected.
not elected, he's not elected.
The only way in which we can overcome this is that the definition of office bearer is president, vice president, chairperson, secretary or treasurer also, but and includes any other person to be elected by the board. Therefore, this election runs through the entire,
Yes,
appointee. If this
Yeah.
could be thought of,
yes,
then
ma'am.
perhaps he is an employee and not an office bearer. Because
ma'am.
he is not part of that board.
Yes, my lord.
He is not elected. He is under employment.
Employment. Employment.
Ultimately, you come to the square one only. Whichever way you proceed, there is no way out.
And
My lord,
45 and 45, your lordship will find confined to only limited to AGM only.
no,
That registered, yes, madam.
Well,
And the honorable single judge has also arrived at finding in the
sorry, my lord.
para 71.
That
Yes,
aspect is not correct.
Yes,
The
yes.
proceeding of
That-
all
that's-
general meeting and special general meeting,
yes.
all general meetings, all.
General meeting is AGM and special AGM. And not the board meeting. Board meeting is not included here. Approval, your lordship will in the top. Delegate general body meeting or and board meeting.
Proceeding, the third line says, proceeding of every general meeting. Proceeding of
Yeah.
every general meeting.
Every general meeting. I am also saying general meeting or annual general meeting or general meeting
And board meeting.
And board meeting.
and board meeting.
And board meeting.
So here the secretary was removed or appointed in the board meeting, not AGM or general meeting. In the board meeting. So board meeting does not require approval of registrar. And single judge has come to the, my lord, observation in the para 71 also in that aspect.
मुश्किल है जनरल मीटिंग क्या होता है बोर्ड मीटिंग जनरल मीटिंग and special general meeting but though in Parliament paragraph board meeting is given how the every proposal is record it is to relating to purpose of record but to relating to approve it board meeting is not.
My lord, if lordship, another argument your lordship just placed me, that he is selected, then he is appointed, then he will be an employee. Then my lord, I have to read 38(2). 38(2) says to nominate, elect or appoint and remove the chief executive. He can be nominated, elected or appointed. So nomination will not be an employment or by election if he is appointed. Because all becomes a member, then from there they get in.
In these cases, all the secretaries who have been removed or who have been
Removed.
Yes,
removed. So they are.
There is no disciplinary proceeding drawn against them. Only a resolution taken in the meeting.
They
That-
Oh, I'm on a different issue. They have been nominated or appointed, but
Yeah.
none of them have been elected.
No.
Appointed, these are appointed.
What happened?
These are appointed ones or nominated.
No.
This appointment is what? Appointment not by virtue of asking for, candidates who can become secretaries.
No,
That's nomination.
Now it is they can employee definition from the actual definition office bearer is excluded.
This we can only like this is for the purposes of the
Hmm.
therefore, he is not elected and who is employed, maybe his name is Mrs. Graham. But this is yes, he's right. So any office, if the secretary is an elected person,
From the
then he becomes an office bearer.
office. Then
If he is not an elected person, then he is an employee.
employee.
If from the members, if he is elected, then he is an office bearer. But it's not fully, fully, the act itself is not that much clear about it.
It is an inclusive definition.
That is all right. So therefore, whether includes any other person who is elected by.
So it's an include, so can we?
So that
Then
this
office space means
this-
president, vice president.
chairperson, vice chairperson, secretary,
And
or
secretary,
treasurer
or
of the
treasurer for
And
plenty.
this secretary is in the context of, because all these persons are elected. President is elected, vice president, elected, nominated. They're not appointed, no,
Not-
they're elected. So in this context, we can read it like this, that the secretary and treasurer's post also has been included in the list of office bearers, but only if they're elected. Suppose they're appointed, then they don't fall in this category because of this. Because it has to be read adjutant generals now.
Because in my case, I was a member and from there I was elected as a secretary. I was a member of the cooperative society, then I was elected from in the board as a secretary.
Not elected, appointed. You are appointed. It is appointed secretary, appointed by the board.
I think when you appointment then.
My lord, page 42, annexure 1. Approval on the resolution adopted in the aforesaid meeting.
Now come to 2L.
2L. 49 2L, my lord.
No,
No.
definition,
Definition.
2L.
dictionary.
Chief executive,
This is the secretary.
my lord.
So it means an individual in paid or honorary capacity nominated or elected or
Or
appointed.
appointed by the
That
board.
option is there.
There
So
are
every case would be different.
different. So, my lord, that why I started with that, my lord, on the, every case has to be on the facts of that case. Only by taking a judgment, my lord, interpreting a judgment will be not that correct, my lord, if I can say so.
Difficulty is here. This explanation we have read. 2L,
My lord,
this explanation we have read. But look at 49(1).
49 1. My lord, before I go to 41, one aspect of the matter,
Just,
they have come before a writ petition.
no, that's true, but
My lord-
let us decide this.
My-
Now let us, there's appears to be an interesting thing. Now, we have read that chief executive could be either elected, nominated, appointed. All right. Now read chief executive.
My lord,
There shall be a chief executive by whatever designation may be called, like secretary of every cooperative society to be appointed by the board or by the state government.
my lord,
So therefore, when we talk about the powers of the chief executive,
No.
he is always an appointee.
appointment,
So therefore, even if you are a member, you're an office bearer,
my lord,
but as a chief executive, you shall be an appointee.
appointment. But
So
as a
that-
secretary, whether I will be a office bearer, as a chief
Therefore-
executive, I will be an appointee.
Therefore, let us see 92 again. And once you're appointed, you're an employee, you don't follow that.
But my lord,
The-
here my submission,
These have to be tweaked.
my lord,
Put
here,
in place.
if your lordship gives me one, my lord, he is the writ petitioner before the writ. He is claiming a relief. That relief has to be based on the pleadings. Whether these pleadings were there, he cannot ask a relief. My lord, that is 2012 8
That
SCC.
argument, Mr. Counsel, fades into background now when these issues have been raised here.
My lord,
Appeal is a continuation.
because appointment or it is, he's,
So therefore this,
Hmm.
I mean, even if it is that, we are not interested in remanding the matter to the single judge to look into this aspect of the matter. Definitely not. So we will decide it.
Ma-
So whether it was argued or not, Pleadings, question of law need not be pleaded.
But the
It can-
facts
it
has
is-
to be
it
pleaded,
is-
not
Facts
here.
is all right. It
But
has to be
whether I am
understood.
the person who was removed, whether I was appointed or elected, whether I am an elected,
Mr. Talukdar, you please find out all laws on this, especially with respect to Assam Act. There has to be some decision of the Supreme Court.
Regarding, my lord, pardon?
All of you, I mean, this is not only to him because you have sought time for this.
Correct. May I pardon, my lord, your lordship has asked to, my lord, to go through in respect of.
I mean, case laws relating to these aspects.
Correct.
Whether, see, a secretary, a chief executive could be appointed, could be nominated, could be. In either case, in case he is appointed, he becomes he ceases to be an office bearer.
No, he's an employee.
He is an employee.
Hmm.
And when he is an employee, then 92 apply, 92 excludes him.
Yes.
If he is an office bearer, then 92 does not exclude him.
Yes.
So these are things which are required to, this has not been dealt with.
Correct.
What the single judge has dealt with is the power of the chief executive officer, the power of the board, and the power of the registrar to enter into such dispute. That was the limited aspect.
Correct.
Now, reading it this way, the aspects become even more, amenable to different kind of interpretation. Something has to be read down, something has to be understood in the gap.
Correct.
And there is no challenge to 92.
There is no challenge, but your lordship can interpret and read down also, my lord. And
Something has to be done for putting a quietus to this. No?
correct, my lord.
Because this would be the source of litigation. Forget
Yes.
about source of power. This would be
Absolutely correct, my
the
lord.
source of
Yes,
litigation.
I agree, my lord.
All right, we will hear all of you again. Just be prepared on this.
Correct.
Take it. We have heard so and so. The primary issue raised in all these appeals are whether the registrar of a cooperative society could decide the correctness of the decision of the board with respect to termination of its secretary, who for all practical purposes is the chief executive officer of the board. In this context, special reference was made to the provisions contained in section 92 of the Assam Cooperative Societies Act 2007, which reads as hereunder. Stop. A registrar, a plain reading of section 92 would indicate that a registrar of a cooperative society, a registrar of the cooperative society, the registrar of the cooperative society would hear any dispute touching the business of a registered society, but would not have the power to hear the dispute regarding disciplinary action taken by a society against an employee of the society or of the liquidator of the society. This perforce leads to a discussion on the definition of an employee. In the dictionary of the Act of 2007, employee has been defined under section 2, subclause 2 bracket S, which means a person, not being an office bearer, comma, employed by a registered society on a salary or similar form of remuneration other than advance patronage dividend or payment for goods sold to or through such society. Office bearers also have been defined under 2 bracket X, which means a president, comma, vice president, comma, chairperson, comma, vice chairperson, comma, secretary or treasurer of a cooperative society, and includes any other person to be elected by the board of any cooperative society. Next, the chief executive of the society also has been defined, which expression means the individual in paid or honorary capacity, comma, nominated or elected or appointed by the board from amongst the members, directors or others in accordance with the bylaws of the society, who shall perform such functions and responsibilities and exercise such powers as specified in the act, comma, bylaws and assigned by the board. A composite reading of these definitions would indicate that a chief executive, which in these set of appeals are the secretaries appointed by the board, could be either nominated or elected or appointed. However, under the act, while providing the ambit of powers which can be exercised by a chief executive, comma, it has been provided in section 49 that every board shall have a chief executive, comma, by whatever designation he may be called, who shall be appointed by the board or by the state government. Thus, comma, there remains a confusion whether the chief executive as conceived of under the act, dispensing with his powers and functions with respect to the board, would be a person who would be appointed from amongst members, directors or others, or any independent person, not an office, any independent person not being an office bearer. All these definitions would therefore pose a further question whether secretaries of the boards should in all cases be taken to be office bearers or employees. This becomes more relevant in interpreting the provisions contained in section 92 of the Act, 92 of the Act, where provision has been made for settlement of disputes by the registrar. If there is a dispute touching the business of a registered society, comma, there is no if there is any dispute touching the business of a registered society, comma, it has to be referred to the registrar. However, with respect to dispute regarding disciplinary action taken by a society against an employee of the society, comma, the registrar will not have such powers. whether such power could be exercised by registrar in case of a disciplinary proceeding taken against an office bearer. The other ancillary question would be whether an office bearer, who is more often than not looking at the list provided in 2X, would invariably be member of the board. Invariably be member of the board. How have I begun this sentence? This sentence only. The other ancillary question. More often than not. Comma, would be amenable to any disciplinary proceeding by the board. All these issues would be required to be answered before these appeals are decided. In some of the cases before us, the secretary concerned was a member of the society who ultimately was appointed as secretary of the board. In some other cases, the secretary is the appointed secretary whose services have been terminated and which termination order has been set aside by the registrar, but the order of the registrar in that instance was interfered with by the learned single judge, holding that the registrar would not have the power to decide any dispute regarding disciplinary action taken by a society against an employee of the society. The learned counsel for the parties would prepare themselves on the aforenoted aspects of the matter and would address this court on the next day. Give your slips, appearance slips, re-notify on the same heading on. You give you 2 weeks, 3 weeks? 3 weeks? 3 weeks. October. Mr. Talukdar, a chief executive, that's the secretary, he has to be appointed because there is a specific provision under 49. So if he is an appointee, then he does not remain an office bearer. All these aspects have to be seen.
If I go for the plain reading of the definition.
Plain reading of the definition of chief executive, all right, but while deciding the ambit of the powers and the functions to be discharged by the chief executive officer, again, plain reading says that he has to be an appointee.
But in some cases, it has been shown that can be elected, nominated.
That's all right. Those are issues which can be handled. But see, basically this. And if he's a member of the board and not an office bearer, and is an office bearer and not an employee, then can he be proceeded against in a disciplinary proceeding? That also is a question which he can't. So these are issues which would require to be decided. The ambit has
92 has been
the ambit has widened.
widened.
You have put this, I mean, the difficulty has been posed to us. You have to assist, let's see. All right, yes, next.
17 October. Item 13 for hearing.
Regularize and BSNL employees.
Yes.
The issue herein is that, the
petitioners herein, my lord, they were initially appointed sometime in the year 1991, 92.
You are appearing for BSNL.
My lord.
All right.
As per the last order, my lord, I was supposed to stay from instructions relating to the directives given, my lord, by the appeals court in Zagdo's case, my lord. My instruction as of
Just a
now,
minute, just a minute. By order dated 15/5/2025. Let's see.
there are two orders, in fact, on first order is of 11/3/25. First order is of 11/3/25.
First order is of 11.
11/3/25.
There is no dispute that they are continuing as
My
casual
lord,
laborers, but
dispute.
then since when is the question which you need to tell us?
My lord.
Now, we may not be in total agreement with the second paragraph in page 18, where the employees would have discharged their primary burden of producing the photocopies.
My lord.
When these are if it were the photocopy countersigned by authority of BSNL,
Hello.
perhaps this interpretation was all right.
It was,
But if it is a typed sheet,
no,
which can be typed anytime,
these are all photocopies countersigned by the BSNL authority.
then the onus has shifted now. Not the burden, but the onus has shifted.
My
You're disputing it.
So the BSNL authorities have denied, my lord, that.
No, you have not. The observation of the bench is that you have till date, you have not denied. You just say that it has not been proved. It is contended that the respondent BSNL has simply stated that the originals are not available with them. But they have not disputed the fact of existence of these documents at any at any point of time. You must have seen this order when it was signed, after it was pronounced. Then what do you have to say?
My lord, can I address on fourth, my lord? Today I'm otherwise actually not prepared because yesterday I was stuck in Zorabat while coming back from Meghalaya.
But look at these.
My lord, that aspect I know.
There are so many of them. Jago stares at your face.
My lord, we tried, my lord. We have been discussing this because there are more than 3,000 such employees, not just these persons. But then the difficulty is that BSNL has cut down, my
That's
lord.
all right, but we are concerned with these.
My lord, we are cutting down posts by almost 293 posts have been cut down. Now to bring 3,000 more people, my lord, we have to again create posts.
No.
Regularization, my lord, to need but posts.
No, their prayer is only for giving them temporary status. Only thereafter they would be regularized.
My lord.
You have not even given that. Giving them temporary status would enhance their salary. They are not asking for regularization. We would be the last persons to tell you. Once that depends upon the vacancy, that depends upon your need. We can't ask you to create jobs. But then since they have been working for so many years and you have yet not, dispensed with their services, that means you require it. And therefore you must give them the temporary status and not hide under the cloak of they're not producing authenticated copies. If it has been countersigned, you need to explain that these are fake. Though principles of Evidence Act would not a stricter sense to apply here.
I know.
But section 100 to 105 is very clear. Now they have discharged their initial burden, the onus shifts on you.
I know.
Burden still remains with them, but the onus shifts on you.
But the difficulty is that the records, the counter records that we produced, this honorable court asked us to look into those. We find that our records are also missing as of.
Fine. That is no ground. That shall be read in their favor.
In fact, division bench of this honorable court in a similar matter, my lord, had held that the benefit of doubt should go to the casual labor.
Exactly, those principles will not say in black and white that there is a positive interdict in using these terms
Correct.
in these matters.
Correct. I understand, particularly because they continue, my lord.
This will have
Almost
very
20.
specifically that you have given the countersigned copy and they have not disputed it. And you say that records are missing from that. And you have allowed them to continue. They are not asking for regularization, they are asking for only temporary status.
Yes.
Is it correct?
Yes, my lord.
That is so, my lord. I
No,
think my
my
elder
lord,
friend also is praying for.
Actually, one of the order,
At the
previous
request of the
order,
learned-
this
at the
honorable court.
request of the learned counsel for the parties, the matter is adjourned to your data. Find out and tell us, you ask your management also what
My
can
lord,
be
my
done.
lord.
Otherwise, we'll have to upturn the order of the cat.
16 October.
Will it be inconvenient before vacation if any date? Much or less.
Obliged.
Item 14.
May it please the court, my lords.
Yes.
Whereas this appeal is preferred against the judgment and order passed by the learned single judge, whereby the disconnection of the electricity connection of the petitioner has been upheld to be legitimate and valid, my lords. Now, my lords, we have preferred this.
Let's not get into this dispute. Have you applied? You can't remain without electricity. You're an advocate.
Yes, my lords.
So have you applied for fresh connection?
My lords, liberty was granted to the respondents to restore the connection to us. However, they have been silent about it, my lords. And
That
your
depends
lordship,
on your application, a fresh application.
yes, my lords. Now, my lords, the
Why do
problem
you
with that, my lord, the problem with that is when this matter was raised before the learned single judge, we had asked them, we had informed the respondents that we would be applying, but they said that that would entail giving us a new connection with a new number, with a new meter and new everything, my
How
lord.
does it make a difference? It's not telephone number, it's the electricity line which is required. I mean, if you just want to litigate, file appeal, then file review, I think you'd be wasting your time.
My lords, if
It
at
cannot,
all,
there can be no two opinions that you cannot remain a consumer of electricity without paying. Now, if there is
Very
no
well.
provision in the supply code with respect to, reconnection after permanent disconnection,
right, my lords.
then perhaps the better option for you would have had been to go for a fresh connection, and even that reconnection charge has been refunded to you.
My
So
lords,
if you only look at the legalese of it and say we are not going to interfere, and we presume that you would not have been without electricity for all these years. Then are you consuming electricity without being on the grid, without paying for it?
My lords, the premises
So
remain
many issues,
unoccupied, my lord.
because if we decide a matter, all these aspects come to our mind. And you can't possibly blame us that we are going beyond our brief.
My lords,
In a case of this kind, look at this. Now, we have sympathies for you for the reason, let me be frank with you, that you have stated in your memo of appeal that you're an advocate,
my lord.
a senior advocate at that. Can you continue with your vocation without electricity supply? Or can you even
Absolutely.
survive without electricity supply? That's one of the
Absolutely.
basic needs, but you need to
Yes.
pay for it. So
Right.
where is the difficulty in getting your new connection? And
Let's,
the electricity board is, the supply company is under an obligation to give it to you once you apply.
My lords, then that would also entail fresh charges, my lord, for new connection.
How
my
does
lord.
it make a difference?
But that amount would be saved if at all, my lord.
Now that you have suffered permanent disconnection, there are
My lord.
other supply codes of other states where there is a problem, where there is a provision for conciliation.
Right, my lord.
I don't think whether you have any provision. Without the provision, what do I do? What do I tell the supply company?
My lord, what we are praying
Anyway,
before this
you
one.
talk to your client. I don't think you're appearing in personal capacity because it
No,
talks
no,
about the
no,
senior.
no,
Tell
no.
him if he's ready, we'll dispose of this off and we'll say, we'll tell the respondent to give you a new connection without delay.
But
Don't delay this.
I'll seek instruction in that
Take note.
respect.
The appellant is an advocate whose electric supply has been disconnected. Stop. It appears from the records that the disconnection took place sometimes in the year 2020 when the entire country was reeling under COVID-19 pandemic. Stop. Later, the appellant paid the dues and also reconnection charges. But before that, the electricity supply was permanently, electricity supply to the appellant was permanently disconnected. Stop. The supply code does not provide for reconnection or restoration of connection in case of permanent disconnection of electricity supply. Stop. In that case, the only option is to apply afresh for electricity connection. Stop. This was acknowledged by the learned single judge who directed the respondent / supply company to refund the amount of ₹600 which the appellant had paid towards reconnection fee. The learned single judge also made it known that in case an application is made for fresh connection, it shall be processed expeditiously without any delay. We are also at a loss to understand whether the appellant is still without electricity. Stop. In any view of the matter, the learned counsel representing the appellant asked for some time to take instructions in the matter whether the appellant would like to apply for fresh electric connection, in which situation this court would be more than willing to direct the respondent to process such a request immediately. List it on after 1 week.
Fine 9.
What's obliged?
Item 16.
I'm sorry, I'm praying for an accommodation today, Lordship.
You should have said that in the morning.
But in the arguing council was
Yes,
here.
but-
The arguing council was here, but because of the personal difficulty, he had to leave, Lord.
Who is your arguing counsel?
A Ganguly, Lord. A Ganguly.
And you don't have the brief with you?
I have the brief, Lord.
Are you ready?
No, Lord.
When?
Any week, any date next week.
As October. Well, it goes on in October, but then it's a dismissal matter. We'll see.
Yes.
You have misappropriated funds. You returned. But amount was staggering, 5 lakhs and thrice.
And
And the amount went in your account. Am I correct?
yes, Lordship is correct.
So therefore, there is no urgency in the matter
But
as prayed for by the respondent.
the thing is that, my lord, I
Let's
was,
see on the same next day,
yes,
as prayed for on behalf of the respondent, pre-notified
Item,
on
item with
in
series.
October.
28 October.
Please don't take adjournment like this when the
I'm-
counsel for the advocate, counsel for the appellant is here.
Item number 17.
may I please, your lordship? Lordship, before coming to the merits of the case, may I submit one thing, my lord? My petition had 2 prayers. One is for mandamus for transfer of the petitioner from one district to another. Regarding that part, I do not want to,
Press the
Press.
petition any further.
yes, my lord.
And what
That's
do you
because
want
he has
now?
already been transferred, ma'am. And the other part, I am challenging particular 2 provisions of the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020, ma'am.
7A and B.
Yes, ma'am. If your lordship comes
Comes
to,
counter to 10. No, is
Yes,
that
sir.
your case?
My-
Now give us the act of 2020, Assam Elementary and Secondary School Teachers Regulation and Posting of Transfer Act 2020.
it is annexed to the
But
petition.
that we don't see, we see the act. What's your guess? Which page?
Page 28, my lord.
I come to see first. Provide for-
Particular provision section.
Just yes, come to 7.
My lord, may I take your lordship to page 35, section 10?
First read 7. Then
7,
we go
ma'am.
to 10.
My lord, inter-district transfer norms of teachers. Inter-district transfer norms of teachers. The government and the competent authority shall be guided by the following norms in respect of inter-district transfer of teacher. Number A, a teacher working in a district continuously for 10 years or more can apply for transfer to his or her home district or to a nearest contiguous district. And B is, a differently able teacher can apply after working 2 years in a district for transfer to his or her home district or to a nearest contiguous district. So particular these two provisions gives a time bar for application. In case of
Now come to 10.
my lord, page 35 is 10, my lord. These are the grounds for seeking transfer. A teacher may seek transfer on the following grounds. Number A, for change of residence due to marriage. Number B, for looking after elderly and ailing parents. Number C, for safety and security of female teachers. Number D, for treatment of the teacher and or their dependents. Number E, for the reasons as mentioned in section 7 of this act. And F, for any other specific and justifiable ground. So my humble submission before your lordship is that section D particularly relates for the treatment of the teacher and his dependents, my lord. So medical.
Yes, yes, master. Does not go well. Now suppose somebody is having ailment today and you would ask him to wait for 10 years, continue serving and then give him the transfer. Transfer could be only after 10 years according to the rules. And that also the 3 places, one home district or contiguous district or
This two only, madam.
home district or to nearest contiguous district.
Yes, my lord.
But then in this case, what difference would it make if you are just posted in the next district? Would it have better medical facilities? You're ill.
No, my lord, in my case, what happened? I am posted around 400 kilometers away from my home district, my lord. So my petition before the respondent authority was that either transfer me to my home district or nearby district. And accordingly, it was allowed, my
You
lord.
can't apply 7A lock, stock and barrel, especially when you provide them the forum for making a request. Take instructions, otherwise we'll read it down.
Well,
Only one confusion in my mind also, my lord, because in section 10, there are 6 grounds, my lord. One is for change of residence due to marriage.
Second is for looking after elderly and
Therefore,
ailing
we
parents.
reject the application, but in case of illness, if you find that
Yes.
he is not malingering, he is not feigning illness, then perhaps you have to have a ground for rejecting the application. But it cannot be a ground that, well, complete 10 years and then, suppose he is suffering from some terminal disease.
10 years can be benchmarked in all cases.
10 years, you can't insist for 10 years in cases of illness.
In fact, Malak, in
Suppose he can always ask for a transfer for looking after his elderly ailing parents. So suppose he's posted today, tomorrow his father who is 75 years of age, he falls ill, he requires attendance. His wife is there, he's a widower.
Yes.
So you'd say that no, wait for 10 years, he'll die. There has to be some sense.
Ground 10E, Malak, ground 10.
Again, we have seen Advocate General, we'll ask the Advocate General. Mr. Advocate General, please. Mr. Advocate General, many a times we put you to trouble, we saddle you with responsibility, but here, see, prima facie, we are finding the rules to be inconsistent. Now, this is a rule which says, this is Assam. We'll just give you an idea,
Lordship.
because you being the first law officer. This is Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020. This act basically is for maintaining pupil-teacher ratio.
Lordship.
So it says that a teacher can ask for a transfer inter-district under only after having served in a district for 10 years. And then he's also given liberty to seek a transfer, inter-district transfer, under some circumstances, including illness of himself or his parents. So therefore, importing the provisions contained in section 7, which makes a transfer possible only if he has served for 10 years, to apply in cases where transfer is requested on medical grounds, it would be absolutely inconsistent.
In that view of the matter, also, I'll definitely make my submission, but this is basically welfare.
That's right.
That's right.
That's right.
We try to give that benefit, at least wait for, otherwise there is absolutely no.
No, absolute no is all right. But then you have given him the permission,
Certain
given the teacher
conditions.
permission to seek transfer in such cases. This is only.
And also we have allowed, I think, mutual is also there.
We are primarily here,
Lordship.
not with respect to mutual. Mutual, he must work for 10 years. Agreed. But say if he's asking for an inter-district transfer on ground of his father's illness. Now, if he waits for 10 years, his father would die.
That is absolutely correct. If Lordship ultimately will not be able to, if Lordship set aside that particular clause also, we'll have.
We will read it down. So
We'll-
therefore, take
yes.
instructions if you.
Yes.
We
That
can
Otherwise, our intention is just to give some succor to the
take instruction, tell us, we'll do it
Lordship.
straight away.
Lordship.
If the government can make a change, well and good.
Yes.
You don't suffer this
No,
you know.
it is basically to the interest of the teachers we have framed.
and
Other-
pupils also.
Yes.
And pupils also.
People's interests should not be suffered. It should not be detrimental to their interest.
Don't take it as minimum condition for transfer even under section 10 under certain circumstances. You can't import the condition under 7 for every such request. Suppose for change of residence due to marriage, it can be understood, but then once marriage has taken place 10 years, the marriage would break.
Look.
Looking after elderly and ailing parents, the whole purpose would be defeated. For safety and security of female teachers, what else? If she suffers an onslaught, who is going to take the responsibility? Reject, say that the apprehension is incorrect. On facts, wrong statement has been made by the teacher. You can reject that. But insisting for 10 years is something which doesn't go well with the statute.
Lordship.
The purpose. There is a salutary purpose behind this act, no? It can't be. It all happens because of the poor quality of craftsmanship, no?
True.
These days, you see the laws of yesteryears. People may talk so much, but
Acute shortage of that kind of people now.
yes,
In our legislative
Yes.
department, 1 or 2
it
persons
is
are
very
complete.
difficult. Persons with lesser qualification also can make good
Yep.
laws. They
Yes.
draft it well. Ask us to draft one page of these rules, there will be thousands of loopholes. The specific trait is required.
Knowing too much is also a detriment. But those persons who are not very highly educated or not knowing the nuances of law, it is easier for them.
Mr. Advocate General, take a call with
Lordship, I'll
respect
do
to
it.
the
I'll do it.
7 and 10.
Lord,
We are keeping it after 2 weeks.
Lordship.
Take that. We'll introduce the subject and we'll say that we have requested the Advocate General to look
Lordship.
into the matter.
It is my duty to appear in this case. In fact, he told me in the morning, but I was engaged in 2 matters and another matter is there. The Muslim Marriage Registration Act.
Yes, we'll do that. We'll deal with it.
Yes.
Take it. Take that. A challenge has been made to rule 7A and B of the Assam Elementary and Secondary School Teachers bracket Regulation of Posting and Transfer bracket close, comma, Act 2020. In order to maintain pupil-teacher ratio and to discharge the responsibilities of the state government to manage posting and transfer of teachers of elementary and secondary schools, comma, the act in question was brought into existence. According to section 7A, a government teacher could be transferred to another district, transferred to the home district or to the nearest contiguous district. What have I said? A government teacher? A government teacher could be transferred by the competent authority to his/her home district or to a nearest contiguous district only if the teacher has worked in a district continuously for 10 years or more. Only after having worked for 10 years or more could such an application be made for inter-district transfer by such teaching. The requirement is lesser for differently able teacher, which is addressed by the provision contained in 7B. Section 10 of the Act provides that a teacher could seek transfer on grounds of change, Roman 1, change of residence due to marriage. उसके नीचे लिखना Roman 2, for looking after elderly and ailing parents. 3, for safety and security of female teachers. D, for treatment of teachers, for treatment of the teacher and / or their dependents. Next number data. For the reasons as mentioned in section 7 of the Act and for any other specific and justifiable ground. In the present case, the petitioner is suffering from illness, but has been posted in a district which is 400 kilometers away from his home district. His request was turned down on the ground of his not having served for 10 years or more in the district where he has been posted. The contention of the petitioner is that the provisions contained in sections 7A and 10 do not go together. Any request for transfer on grounds of ailing parents or personal ailment or change of residence or for safety and security of female teachers cannot be defeated on the ground of the teacher making such a request not having served for 10 years or more. The whole purpose of giving the concession to a teacher to seek transfer on these grounds would stand defeated if 10 years work experience in a district is insisted for in all instances where transfer request is made on grounds of ailment, etc. Stop. Under this circumstance, we have requested the learned advocate general to look into the matter and if possible, come out with necessary rectification in the act, if possible, by the next date, re-notify on so and so date. Many a times in Bihar, in Patna High Court, we used to address the issue to the advocate general and within 2 weeks, 3 weeks, necessary modifications were made. Otherwise, we'll direct for it.
Maybe a clarification will do, Lordship, in this case.
Clarification.
Yes, clarification.
Whenever you say
I'll make my submission.
3 weeks,
I have,
he's not.
no, I think he has already got the relief.
Yes.
He's already, you have already.
My lord.
All right, 4 weeks, then 4 weeks.
Lordship.
Lordship has observed that I have applied for transfer for my own illness, not for my own illness, for my parents.
For the illness of his parents, both parents,
Both parents.
for the illness of both of his parents. All right.
30th October. 30th October. Item 19 to 21.
Time. So this is the last part. Yes.
My lord, marriage is my 2019, this act was passed. Till now, marriage are almost stopped
No,
now.
we are not, we do not know the facts of the case. You have to argue afresh.
Yes.
Is it coming for the first time?
Item 19, 20, 21.
Anna, is it coming for the Mr. Dictation?
Notice issue, my lord.
If it's also filed, case is ready for hearing.
Okay.
All right.
If it is the file, man, practical. This is cases, my lord, this is all some Kazis, my lord. Normally, my lord, initially your lordship is aware 1880.
I'm not aware.
My lord, 1880 Kazi Act. 1880, my lord. That Kazi Act makes, my lord, the appointment of Kazi is to be made in particular areas. My lord. So, 3 acts are involved here, my lord. 1937 Act, Sharia Act, application 1937. It protects the personal law. Marriage, divorce, inheritance, etc. 1937 Act. So this 1937, it deals with the Muslim law, personal law, and then Kazi Act for appointments of the Kazis, and 1935 Act, my lord, which in Assam Act, my lord, it says about the performance registration of the marriage. Register the marriage. Now registration initially it was voluntary. Subsequently in 2010 it was made compulsory, my lord. So now the one of the objective of this my lord, it is repeal of the act. 1935 Act has been repealed now, and thereafter a new act has come into it. In the new act, my lord, only what we find that only about the child marriage in the 1935 Act, my lord, minor. Only if there is a minor, guardian is to represent him or her, my lord, in 1935. So only what I find from the reply they have given, it falls on doctrine of severity under Article 13, my lord. If one of the provisions might have found that it is not inconsistent with that, my lord, then it can be done by making an amendment. Now, second part is my Article 245 of the Constitution of India, my lord, 245. Now the inconsistency matter, because 1937 Act, Sharia Act 1937 is still today it is a valid law, my lord. And once you take away that right, because registration, they have now come only for registration, non-solemnization of marriage. Solemnize for that purpose, my lord, a person having Islamic jurisprudence is required, my lord. That is what they are, my lord. And these persons are appointed on the basis of their knowledge in the Islamic, because ceremony of marriage, solemnization of marriage is concerned. So solemnization of marriage is concerned, once we go for registration, my lord, it says, new act says that at the commencement or prior to that year, my lord, only one can go for registration by the district registration officer. District register and as per Registration Act. It is to be registered before him. Now the question matter, solemnization of marriage and registration, that was done now. Who will solemnize the marriage? So these Kazis, they were appointed means license was given just to perform, my lord. They are not given in salary, etc., my lord. they have been allowed to, my lord, perform the marriages and record in the record book, my lord. And they are also public servant. They have to bring anything on the record, everything on record, my lord. So now the purpose of this act is, my lord, my whole question is, my lord, if there is, what is the purpose of bringing this act? Second question is, if there is a conflict within the central law, and because it is in concurrent list, state also got a power. But if it contravenes the central act, my lord, it must take the assent of the President of India. 254. 254, my lord. That has been not done here. So this is the basic, my lord, things here.
Just give us 2 minutes. Let us see the act first.
My lord. Original act,
No.
new one. Or 24 is the page, your lordship will have page 128. 126 is repeal and 128 is there of my petition. 128. Original একটা page কত? Original একটা page কত? Hmm? Hmm. Sorry? Hmm. Page কত?
Ini mau ikut aja itu kita pun mau ikut party. Nah, aku अपना kita tadi kita tahu. Dia itu pulau betul. Dia itu pulau betul. Itu tuh pulau mana? Ya, tapi kita sudah tahu itu dia. Nah, soalnya dia tuh dia kan seperti tadi kita laporan tadi dia itu itu boleh dia boleh ya boleh es pas itu dalam pasal nomor orang opening na itu dia no boleh betul asal itu dia boleh ini kita tanya kita ambil tulis itu dia no boleh kalau kita kan loh actual kita masih ada untuk ini kita kalau kita mikir tapi semua ada dengan apa kan terjadi biar putus dengan dia jadi apa memang 1937 Section 2 to relieve. Maybe short. It appears the source into the government. Ya, pun ya, ini Muhammad dan Thompson lagi. Not a little correct because we are they can themselves in the way. Kita cerita ini perlu dilakukan itu juga. Jadi itu adalah kedua. Atau lebih baik Israel dan Palestina itu lebih besar. Atau tapi kita penting. Tapi dari itu original dengan. Tapi orang itu itu buat mana pun. Perfect. One of the tools I love more people. And look, no, I think consider
Incomplete. Incomplete. Is that in the crowded?
Just the political place.
Yes.
Yes, much. I think your lordship is. So the basic question are your lordship will find what is the object of that? My lord, page 128, your lordship on this. 128. It starts from, yes. To provide for, your lordship, for compulsory registration of Muslim marriages and divorces in the state of Assam, and to protect the rights of married Muslim women and men for matters connected herewith or incidental. Nothing is about this second part in that. So for first part you're concerned, your lordship will find, if your lordship come to page, my lord, already is compulsory, my lord, your lordship will find page 69. Page 69, original act, 1935 act. Amendment in 2010. Your lordship will find bottom, 2A. 2A, my lord, it was inserted in 2008-6-2010. Registration of Muslim marriage compulsory. Subject to the other provision of this act and the rules made thereunder, registration of Muslim marriages and divorce are compulsory within the state of Assam. Already my lord, compulsory is there. And so far the second part is concerned that to protect the rights of married Muslim, nothing, no whisper in this, my lord, act at all, my lord. So only to make it compulsory, already it is there, my lord. And your lordship is very much aware about the mohar in Muslim marriage, but it is integral part of the marriage. Ijab, Kabul, my lord, proposal, acceptance, witness, and dawar. Dawar money, that means mahar, my lord. It is integral part of the marriage. About the marriage, about that part, and some, my lord, ceremony is there in that here, my lord. At present, what Kazis do, my lord, normally at the time of the marriage, they personally go there, my lord, with the register. And in their presence, some ceremonies are taken place, and thereafter they register on that basis of that here, my lord. At present. Now, the present one day, my lord, district register is to register it. District register is no knowledge about that here, my lord. Maybe some one or two, but normally, my lord, here these people are normally nominated only when they're satisfied they are well versed in Islamic jurisprudence, Islamic law. That's why the mandatory qualification is, my lord, they must have some knowledge in Arabic, etc., Quran and Hadith, my lord, integral part of that. These are not there. Mohar, that is dawar, is not there in the new act. So ultimately it affects, my lord, Article 1937 Act, my lord. Will marriage, dawar and divorce. It is there in 37 Act, it is integral part of that personal law. So that no longer it is there.
That has not been interfered with.
Yes.
The Act of 1937.
So, my lord, once marriage ceremony, your lordship kindly see, what is marriage? What is the essential of marriage?
Essential, we understand, there should be consent, there should be
Contract, there will be witness, there mohar.
and there should be khutbah.
Khutbah. Who will be registered district register will be khutbah, my lord?
The Muslim Personal Law Shariat Application Act 1937 is that they are not providing any ceremony. See, this act, this new act of 2024.
Why? Why? What is the object?
Your object is all right, we will discuss about it.
Object is not a compulsory register of marriage.
Let us first understand how does it compare with your rights? I mean, the ceremonies that is governed by this Shariat law.
Yes.
The act says so.
Yes.
Section 2 of Muslim Personal Law Shariat Application Act
1937.
It's a central act.
And that is upheld by the Supreme Court also time and again. Your lordship is very aware.
That is the reason to fear.
Yes, my dear lord.
So that you do.
No, my lord, so far this register is concerned. Now what they are doing, my lord. My question, my lord, object is if only to compulsory register marriage, that is already there. Then why for this? These persons,
For that, see,
these persons are under complete. If suppose some individual Kazi is, yeah.
that's right. But you see, the Act of 1937,
Yes,
of course, by amendment in 2010, this registration was made compulsory.
right, right.
But it still runs counter to, before it was repealed, counter to many acts where there is an age bar for marriage.
Section 8 is there, my lord. Simply by making an amendment can be done. If one particular provision there, Article 13 is there, my lord.
Mr. Chaudhary, you have to tell us whether the state is competent to enact this or not.
No, I am not on certain, my lord. I am not questioning competence, my lord.
तो कहाँ देखा?
I am on my lord because it is inconsistent, repugnant to the 1937 Act.
Set rules, there are set grounds on which an act of a legislature could be interfered with or set aside or read down.
If it is inconsistent, repugnant, then your lordship, that your lordship
It
can,
has to be set aside.
yes.
To that extent.
So that your lordship will see only, my lord. I am not questioning competence, my lord.
It is not bad, it is not hit by non-competence. It is all concurrent jurisdiction, marriage.
Yes, concurrent jurisdiction,
Law
yes.
always.
But if it is, my lord, if it relates to the Central Act also, my lord.
Because there was an existing law, this law is.
There's no composite law, my lord, everything is there.
Ground that if there is a law which takes
Already.
care of all these provisions, therefore this law should not be made.
No, law is, but so far 35 Act is concerned, my lord. You'll have to kindly go through the 35 Act. Everything is there, my lord. Everything is there. Whole question, my lord, who will decide? Who will decide that how the marriage, but they are the person who remain present. And now what your lordship will do, they have to go, 30-day notice is to be given, they have to go, villager people, they have to go to the town, they have to apply for that yet, advocates will be there, advocates clerk will be there.
Just give us a brief, 3 pages, provisions of the new act,
Lordship,
which are not there in the earlier act
Lordship,
and which is mandatory
Lord.
according to other acts, let's say POXO Act,
Yes.
Marriage Act, or some, list those facts. And otherwise, give us those case laws.
Case laws also I have prepared.
Which are?
Today I'm not
So,
complete.
Faragabano
I
case
will-
is,
No, no,
oh, latest one, latest.
not with respect to that, with respect to the power of the court to deal with, these
That's so that.
new legislation.
Yes.
Legislation.
So, एक जगह दिखेगा.
They didn't.
Give us in one format,
Lordship.
we say arguments to continue. We have heard Mr. H.R. Chaudhary, senior. Who's this senior?
There are 3 or 4 other cases also
Lord,
of different senior councils.
My lord, I have also filed, my lord, 2 public interest litigation petition, my lord.
Contempt
Along with
21,
them.
items.
My lordship is concluding the hearing, my lord.
I'm continuing with you.
My lord,
I'm
Yes.
continuing with you.
continuing. Then, my lord,
Continuing.
Then, my lord,
Where are your matters listed?
my lord, today. itself-
Today it is there, man,
All right.
along with.
Arguments to we have. This is not the subject, but this cannot be a subject matter of PIL.
No, my lord, my lord,
Anyway,
the,
We have,
I will try, make an attempt to satisfy.
we have heard,
My lord.
the positive interdict, PIL cannot be entertained for this.
Anyway, madam, but lead cases there.
We have heard, we have heard Mr. Swans, we have heard Mr. H.R. Chaudhary, learned senior advocate, and Mr. Bhuyan, learned advocate for the writ petitioners and the learned advocate general for the state in all these matters. Arguments to continue, to re-notify under the same heading. To 3 weeks, October.
Lordship, there are 5 other cases. Can they come?
Yes,
Because there is different councils.
30th October.
Other
Let
cases,
these appeals also be listed.
madam, date is, madam, we are now, madam, marriage are now.
Just a minute.
Some short date, my lord.
The learned advocate general has informed this court that there are 5 other writ petitions, namely disability, also pending consideration before this court with similar issues. Let these writ petitions also be filed along with the present set of writ petitions on the next date. Take this.
Yes. 30th
October.
October. 30, okay,
August,
October.
October. Too long, my lord. Can it be, madam? Madam, I agree your lordship, but these people are waiting. Madam, marriages are not being held now that in that way, madam.
So,
What of them? Normally,
What is
I-
your, that?
no, I'm not saying, my lord, not the way how it ought to have been done.
Raise that argument, we are ready to decide it
No,
now.
no,
The act is not.
my lord, I am saying the marriage is not taken as the ought to have been taken place.
No.
That is what I'm saying.
Absolutely
But
wrong.
who will register is now, my lord.
So
That has not been.
who stops a Kazi? See, it's
No,
a,
marriage,
आप अपने private, this is.
वो private तो मुझे चल रहा है साहब, वो तो कोई बात
Marriott Act 1935 and the Applicability Act 1937 says that you can proceed in accordance. with
misuse will be there, my lord. Either this
No,
way or that way.
This is misuse.
No,
And Kazi Act has not been repeated.
yeah.
Lord,
No, no,
It is.
subject is
it
there,
we can-
but Kazi Act,
1880 Kazi Act.
Apprehension.
but we are the Kazi, then we may be allowed to perform, my lord. We may be allowed to perform till the
If
disposal.
we have the two grounds, then we decide it today.
No, suppose in that case, we may be allowed to perform the Kazi, act of Kazi, my lord, till the disposal.
Registration is not permitted to them. They
Registration
can do all other activities.
purpose is to take this registration thing out of you. You will not register, you.
My lord,
and
there must be some reason, my lord.
Just a
Whether
minute,
I,
just a minute.
yes.
If the marriages are not on the state grid, there can be no enforcement of the rights.
No, that, I understand your lordship, what your lordship meant to say, my lord.
Lord, only the
It has to be on the grid.
Uh,
And so far as solemnization is concerned, the apprehension. is-
solemnization is going on, my lord. Solemnization is
How
going on.
did we,
Only
I
the,
would have made so much of furore if marriage would have been stopped.
Lord, the registering.
And
authority-
this, all these essential elements of marriage would continue according to your personal law.
Who will decide, man? That is the only question, my lord.
Kazi remains a Kazi.
The Kazi, these are the person.
Just a minute, before that, you never
They-
got paid. Just a minute, Mr. Chaudhary, you
Yeah.
never got paid for performing.
No, when we get some percentage that is they have now given from 13, my lord.
Collect it from the parties who engage.
Now, if you also give that observation, they do, my lord.
What observation?
That they may have their own dues, whatever is there, my lord.
So you. will
Some
start-
percentage of the dower money they take now, my lord. Only 3%, 2% of the
Good,
dower.
Mr. Chaudhary, you have come here for challenging the repeal act. on
My
the
lord, these
UN.
people are your lordship.
Court, you ask the court to say that you can appropriate some part of dower amount which is meant for some other.
No, no, that is there already they have made, man.
Kazi fee.
By amendment in 13, they have given some amount, my lord. From the that. Anyway, my lord.
There is no,
Your lordship
see, there
fix
is no ground actually.
that I am not saying, I am just by the way
All
that I am saying.
30th of October.